ಕೋರ್ಟ್ ಆಫೀಸರ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಮ್ಯೂಟ್ ಅದಿದೆ ಸ್ವಲ್ಪ ಚೆಕ್ ಮಾಡಿ. Court officer.
ಹೇಳಿ ಸರ್. Number 25 and 26. Page number 9. Number 27 to 30.
Adjournment ಬೇಕಾ?
Bench ಅಲ್ಲಿ ಇದೆ ಸರ್.
ಇದು ಯಾವ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಶುರು ಆಗಿಲ್ವೇನು? ಆಯ್ತು, ಬಟ್ ಇದ್ರಲ್ಲಿ ಯಾವ್ದ್ರಲ್ಲೂ ಆರ್ಗ್ಯುಮೆಂಟ್ ಶುರು ಆಗಿಲ್ಲ. Request of learned counsel for all parties. List these batch of matters. After 2 weeks.
Page.
ಹಾಕಿದ್ದೀರಾ? ಹಾಕಿದ್ರೆ ಅದು ಬರುತ್ತೆ. Once you file IA, it will come for hearing IA. At that time, you can argue.
Page number 14, serial number 31 and 32.
My lord, serial number 31, my lords. I appear for the respond number 2 in this case, my lord. Insurance company, my lord. If the LCR may be called for, my lord, if it received, my lord, may be referred to Lok Adalat.
Lok Adalat?
If the LCR has been received, my lord, the matter may be
Registry to
pending.
secure TCR. All
Please,
after
ma'am.
2 weeks.
Page 15, serial number 33 to 38. Page 16, 39 to 43. Page 17, 44. Page 18, 45 to 50. Page 19, 51 to 55. Page 20, 56 to 60. Page 21. 59.
Matter is settled. Yeah, who's a respondent? He has come.
Satiksha.
Bandidara. At request of both the Senate Council, this matter is referred to Lok Adalat.
Let's serial number.
You're for? At request of appellant, call this matter next week.
Let's serial number 67, my lord.
Page 21.
Connected
68
matter.
to 64.
60.
Page 22. 67.
Serial number 67, my lord. Connected matter also. Both insurance company also. I gave one list, my lord.
67.
Please, my lord.
New matters idea.
In the matters, the list ಕೊಟ್ಟಿದ್ದೀನಿ so.
Call these below matters along with these appeals. All after 2 weeks.
Please, my lord.
Page 23. 68 and 69. Page 24. 70 to 75. Page 25, 76 and 77. Page 26, 78 and 79. Page 27, 80 to 84. 85 to 114 matters transferred to quota number 29.
85 onwards. 114 matters are transferred to His Lordship Justice Poonacha's court. Yes.
List 1 for orders, serial number 1. C. Vijay Kumar. 1. 16 transfer to quota 29, madam. Howdu, madam. Display ಹಾಕಿದೀವಿ ನೋಡಿ madam. Serial number 1, C. Vijay Kumar.
This is second for the respondent. One matter that both are connected matters. First matter is cited the petitioner.
My lord, Mr. Vijay Kumar is not in station, my lord. It may kindly be.
All right, who was this Vivek Holla? You are for the claimant.
1.1.
Who are you appearing? You are all right. Which respondent are you in the first matter? Take notice. Who are you? Who are you, sir?
Appellant.
First matter I am the petitioner.
Yaru claimant.
27, 26, I am the petitioner.
Learned Counsel Sri Vivek Holla. You dare to take notice for respondent number 1. How many other respondents are there in your case? Issue notice to other respondents, if needful, done within a week's time. What is the state in your case? Non-filing of synopsis, arguments, production, affidavit filed by 1 to 3. Records are here. Registry to secure records.
Received.
Huh?
Received.
It's not admitted. Well, it's for admission. Issue notice, sorry. The other respondents.
Serial number 2.
Copy to be served. Sir, you copy.
My lord, serial number 2, I appear for the appellant, my lord.
Copy for the
Sometime-
respondent claimant, my lord.
Some time is going to be granted, because third I have taken twice, my lord, these steps. My lord, now I will file an application for paper publication.
A week's
So
time.
your
granted.
lordship may kindly grant some time.
Week's time.
2 weeks, kindly your lordship.
1 week. You want 2 weeks?
2 weeks may kindly be, my lord.
Date may be
2 weeks,
given.
my lord, because only
Alright.
for this purpose, we have to send the application
Alright,
and affidavit.
2 weeks. Call the next case.
Bill number 3,
Obliged.
Rangegoda NR.
Week's time granted if needful done notice to respondent.
4, Kalpana PV.
Week's time to do the needful.
5, Pallava R.
2 weeks time granted to do the needful.
Syllabus 6, Kailash
Await.
Thakkar PM.
Wait notice.
7,
In this case, you have to have find application for issuing.
Madam ನಿಮ್ದಲ್ಲ ಅದು.
Madam, sir.
ನಾಗರಾಜ್ ಹೆಗಡೆ. ಹಾ.
ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದ್ದೀರಿ ಅದರಲ್ಲಿ ಹಾಕಿದ್ದೀರಾ ನಂಬರ್
1782/2020.
ಕಾಲ್ MFA so and so along with this
1782
It
of
is posted today, your lordship.
ನಂಬರ್ ಇದೆಯಾ ಲಿಸ್ಟ್ ಇದೆಯಾ ಇವತ್ತ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆಯಾ
ಅದು ಸೀರಿಯಲ್ ನಂಬರ್ 13 ಮೇಡಮ್ 7 ನಾಗರಾಜ್ ಹೆಗಡೆ.
No, you are, madam, in this matter, you are there for R3. But your name, Manjula Tejasvi, Emma, ಅದು ಬಂದಿಲ್ವಾ ನಿಮಗೆ ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಬಿಕಾಸ್ ಇಟ್ ಇಸ್ M is added. Tejas swim.
In that case, they have not served.
No, but have you received the cost list?
I might have missed it, your lordship.
No, because of that M probably you may not have.
Probably that mistake is in the
Ah,
spelling, your
all
lordship.
right. A week's time granted.
Copy
to the
book
needful.
has also been not served upon.
If needful, done issue notice to R2. Registry to rectify the name of learned counsel for R3 as Manjula N Tejasvi. And show the
Syllabus.
correct name in the cost list.
Bill number 8, Pradeep B.
Amount is deposited,
For applying press week's time, my lord.
week's time granted at request of appellant.
3 months.
9, Janardhan Reddy.
Week's time to do the compliance,
10, MJ Alva.
await notice.
My lord, serial number 10, I am a pair per respondent. I have
Yaru.
received Wakala day before yesterday.
What's your name?
Ramesh Babu.
Registry to show the name of learned counsel Sri Ramesh Babu R. Was filed wakalat for respondent.
Respondent.
Obrena.
Cooperation.
Copies to be furnished.
Hearing on IA, Bill number 11,
The respondent, my lord.
S. Nirmala.
Yes, Madam Nirmala. Unmute ಮಾಡಬೇಕು. ನೀವೇ ಮಾತಾಡ್ಕೊಂಡ್ರೆ ನಮಗೆ ಕೇಳಲ್ಲ.
Oh, sorry, my lord, sorry.
ಹಾ.
So, ನಾನು appellant 9 ಕೇಸ್ ಇದೆ. In
ಹಾ.
that, my lord, MFA 215, the R1 notice summons is not been sufficient. They have listed, my lord. And somebody is appearing for all the 8 cases, my lord. So, Shruti something. If she is there, my lord, she may be directed to take notice, my lord.
Yes,
You are-
Commissioner, I will take notice to that case also.
215 appeal.
So you are appearing for the claimants, is it?
I am appearing for claimants, my
So
lordship.
even in this MFA 215, you are,
I will undertake, my lordship.
all right. Shruti as SP, no?
Yes, my lordship, Shruti SP.
Learned counsel Sri Mati Shruti SP is directed to take notice for, undertakes to take notice for R1.
Yes, my lordship.
Registry to show her name in the cost list, copies to be furnished. So we'll allow all the IAs for delay.
Yes, my lordship. ಒಂದೇ ಬಸ್ ಆಕ್ಸಿಡೆಂಟ್ 1 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದಾರೆ ವೆರಿಫೈ ಮಾಡಿ. ಮೆಡಿಕಲ್ ಬಿಲ್ಸ್ ಆದ್ಮೇಲೆ ಕೊಟ್ಟದೆ 3,000 ರೂಪಾಯಿ. ಇವ್ರು ಚೆಕ್ ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬೇಕಂತ ಅದರ್ ಆಕ್ಸಿಡೆಂಟ್ ಅಲ್ಲಿ ಇಬ್ರು ಸತ್ತೋಗಿರೋರು ಡೆಪಾಸಿಟ್ ಮಾಡಿ ಕ್ಲಿಯರ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಈ ಕೇಸಸ್ ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬೇಕು ಅಂತ ಈ ಡ್ರಾಗನ್ ಮಾಡ್ತಿದ್ದಾರೆ ಡಿಲೇ ಆದ್ಮೇಲೆ.
ಯಾಕೆ ನಿರ್ಮಲಾ ಮೇಡಮ್ ಡ್ರಾಗ್ ಆನ್ ಮಾಡ್ತೀರಾ?
ಆತರ ಇಲ್ಲ ಸ್ವಾಮಿ, ನಮಗೆ ಗ್ರೌಂಡ್ ಇದೆ, ನಾವು ಅಪೀಲ್ ಹಾಕಿದೀವಿ ಸ್ವಾಮಿ. That is not the way they can submit. We have a ground, we have filed the
16ನೇ ಇಸ್ವಿ ಆಕ್ಸಿಡೆಂಟ್. ಅವ್ರು ಎಲ್ಲರಿಗೂ ಮೆಡಿಕಲ್ ಬಿಲ್ಸ್ ಕಟ್ಟಿದ್ದಾರೆ, 1.5 ಲಕ್ಷ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. ಈಗ ಇಲ್ಲಿ ಡಿಲೇ ಆಗ್ತಾ ಇದೆ ಮಾನ್ಸೂನಿ.
So, I have a ground, I have filed my appeal, let the court decide it.
All are injury
And-
cases.
All are injuries, my lordship. 1 lakh, 2 lakhs, maximum 2 lakhs ಕೊಟ್ಟಿದ್ದಾರೆ. Medical bills ಆದ್ಮೇಲೆ 10,000 extra ಕೊಟ್ಟಿದ್ದಾರೆ.
Each case, whatever is the delay,
ಎಲ್ಲ ಡಿಲೇ
Ayo.
ಇದೆ ಹಾಕೊಂಡು.
one of 19 allowed, 117 days, 126
Admission
days,
maybe
or
posted.
number of delay, IA is allowed.
Dispensation.
My lord, in one appeal, my lord, 440, there is a dispensation, my lord, for R2 and R3.
7.5. Dispense, notice to R2 and 3 is dispensed. Delay of 117 days allowed. Illide madam 400 days. Yavrallu ilvalla?
Driver and iವರು some.
No, there is no
Diesel.
400 days in any of this case. Any other cases there? No. Yes, next. This for admission.
Date may be
all
fixed,
the-
my lordship. It's a 16 accident.
Call for records ಮಾಡಿ some. Records ಬಂದಿಲ್ಲ.
Call this matter on, secure records, call on 12th March.
Much obliged.
12ನೇ ತಾರೀಕು.
Number 12.
This case, my lord, I will take, my lord, the paper publication.
ತಗೊಂಡಿದ್ದೀರಾ?
ತಗೊಂಡಿದ್ದೀನಿ. Is two respondents, my lord, R1 ಗೆ.
Counsel for appellant has filed IA 1 of 25. To take out notice to respondent number 1 and 3 by way of substitute service through newspaper publication.
In the newspaper. Punjab Kesari.
Punjab Kesari Haryana edition of Haryana edition to which is a Hindi daily newspaper. And for respondent number 1 and for respondent number 3 in Indian Express Mysuru edition, English daily newspaper. Full stop. Peruse the affidavit. Being satisfied, the reasons assigned cost shown and the notice having not been served with through regular process. Affidavit alama, memorandum of facts. Applications are allowed. Appellant is permitted to take out notice to R1 in so and so and R3 in so and so newspaper. Publication shall be taken out on or before.
10th March by showing next date of hearing 24th March.
And the office is directed to issue separate drafts, my lord. Two drafts is correct.
Registry is directed to issue 2 separate drafts for R1 and R3.
Much.
Number 13. This case.
Applications for issuing paper publication to respond number 5. And
Notice
memo for
to
dispensing.
R1, R5
Yes, it
is sought to be taken out by substitute service through newspaper publication
is the
in Samyukta Karnataka Kannada daily newspaper
Bangalore edition.
of Bangalore edition. Peruse the affidavit, being satisfied, the application is allowed. Appellant shall take out notice to R5 in Samyukta Karnataka Kannada daily newspaper of Bangalore edition. Publication shall be taken out on or before.
10th March by showing
R4,
next date of hearing.
R4, I have filed application memo for dispensing notice. He is only a driver.
R4,
Yes, your lordship.
notice to R4 is dispensed. Memo accepted.
Still number 14. P. Mahadev Swami.
This connected matter, your lordship. I'm the insurance company appeal 1171. I have to take steps, your lordship.
So first
For
matter, you're appearing for R5, is it?
Yes, your lordship. In the second matter, I'm for the
Notice
appellate.
to R3 is sought to be taken out by way of newspaper publication by the appellant in Proceedings Kannada daily newspaper of Bangalore edition. The affidavit is satisfactory, same is accepted. IA is allowed. The appellant shall take out notice to R3 in Hosadiganta Kannada daily newspaper. Publication shall be taken out on or before.
10th March by showing next date of hearing 24th March.
Copy is not given to you?
No, your lordship.
Copy to be served to learned counsel for R5.
Corrected in R4 there.
What about in your case, madam?
He's the same respondent, your lordship. Just now, your lordship has issued,
So what do you want in
yes, I will also file an application for.
a week's time granted in the connected matter for needful to be done?
Yes, obliged.
15. Nagaraja B.
Nagaraj,
ಅವರು ಇನ್ನೊಂದು ಕೋರ್ಟಲ್ಲಿ ಎಂಗೇಜ್ ಆಗಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಟೈಮ್ ಕಾಲ ಮಾಡೋದಕ್ಕೆ ಹೇಳಿದ್ದಾರೆ.
ನೀವ್ಯಾರು?
ನಾವು ಸೀನಿಯರ್ ಇದು ಜೂನಿಯರ್ ಸ್ವಾಮಿ.
ಹ?
ನಾವು ಅವ್ರ ಕೆಳಗಡೆ ಕೆಲಸ ಮಾಡ್ತಾ ಇದೀವಿ ಸ್ವಾಮಿ.
You're advocate?
ಸ್ಟೂಡೆಂಟ್ ಸ್ವಾಮಿ.
Student?
Yeah.
Student uniform ಹಾಕೊಂಡೆ?
ಬ್ಯಾಗಲ್ಲಿ ಇದೆ
ಹ?
ಬ್ಯಾಗಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ, ಹಾಕೊಳ್ಳಿಲ್ಲ. ಯಾಕೆಂದ್ರೆ ಸ್ಟೂಡೆಂಟ್ ಅಲೋ ಇದೆಯೋ ಇಲ್ಲೋ ಅನ್ನೋದು ಗೊತ್ತಿಲ್ವಲ್ಲ ಸ್ವಾಮಿ, ಅದಕ್ಕೆ.
ಎಲ್ಲಿ ಓದ್ತಾ ಇರೋದು ನೀವು?
ಸಿ ಲಾ ಕಾಲೇಜಲ್ಲಿ.
ಹ?
ಸಿ ಲಾ ಕಾಲೇಜ್.
ಸಿ?
ಹಾ.
ಎಲ್ಲಿದೆ?
ಅಯ್ಯಪ್ಪ ನಗರ ಇದ್ರಲ್ಲಿ ಎ ಕೃಷ್ಣಪ್ಪ ಸರ್ ಅವ್ರದ್ದು.
ANB ಸಿಕ್ಕಿದ್ಯಾ ಲಾ ಕಾಲೇಜು?
ಏನ್ ಸರ್?
ANB ಲಾ ಕಾಲೇಜ್ ಸಿಕ್ಕಿದ್ಯಮ್ಮ? ನಿಮ್ದು ಸಿ ಅಲ್ವಾ?
ಸೌತ್
You have
ಈಸ್ಟ್
to wear
ಏಷ್ಯನ್
the
ಎಜುಕೇಶನ್.
uniform even if you're a student.
ಓಕೆ.
Can't appear like that. All right. You have any objection?
ನೋ ಮರಾಶಿಪ್.
About 2 of 22 is allowed delay of 299 days is condoned. She's a claimant, appellant is a claimant.
No, my lordship, owner of the vehicle. I am for the claimants.
All right. 299 days delay condoned.
Syllabus
This for admission.
Date.
Come up next week.
Much.
Gurudev Prasad KT.
I appear for the appellant, my lord.
Is any objection?
No, my lord, it is
Yes.
our, now I have filed an application for withdrawal of the amount. It is a owner appeal.
The second respondent insurance company has filed the application.
What?
And I have no objection. Let the insurance company withdraw that amount.
Why?
Well, we have proved our defense, but there is no DL before the tribunal. Pay and recovery has been ordered. We have satisfied the entire amount before the tribunal. Who filed the execution, when you have filed the execution petition, the appeal has been filed. It's a owner appeal. And instead of allowing me dismiss the appeal,
You're deposited, Mr. Gurudev?
Yes, I have deposited the amount. Let him withdraw that amount.
Or entire amount you have deposited?
entire amount, instead of dismiss the appeal, or transfer the appeal, transfer the entire amount to the tribunal, will withdraw the entire amount before the tribunal and balancing execution.
So you are admitting that the liability is on you?
No, I have to produce the driving license. Meanwhile, let him withdraw the amount which I have
Please,
deposited, 50%.
Kindly say entire amount, please, madam. Include 25,000 plus for stay compliance amount also.
Whatever 50% of the amount, let him withdraw. Entire 50%.
All right, here the order.
Yes.
Learned counsel for the appellant and respondent number 2 are present. Learned counsel for respondent number 2, insurance company, has filed an application seeking withdrawal of the amount deposited for this court, including the statutory deposit.
Please, madam.
The appellant, who is the owner of the offending vehicle, has referred this appeal challenging the judgment and award. Liability is fixed on the appellant, owner of the offending vehicle. He does not have much objection in the respondent insurance company withdrawing the amount. Under the circumstances, this application is out. Respondent number 2 is permitted to withdraw the amount deposited before this court.
Please, madam.
Both are before this.
Both,
court.
both, your honor.
Before this
Both.
court. The registry of this court shall disperse and release the amount in favor of respondent number 2 by way of electronic transfer on the respondent number 2, furnishing relevant bank details on.
Please,
the
madam, furnish.
registration.
Syllabus 17, D. Vijay Kumar.
For the respondent, my lord, I filed the application to release the.
Yes, any objection, Vijay Kumar? What is that is challenging? What is challenging?
Is the both quantum and liability.
Liability also.
Please, my lord.
We'll have it next week. We're not here.
Please, my lord.
Request of appellant call this matter next week. Counsel for respondent is present.
Number 18,
I am for the respondent in the same case, my lord.
Withdrawal. Anup Sitaram. Yes, any objection?
No, like 60% amount is deposited before the amount, MSCT, out of which 50% may be permitted to withdraw.
What are you questioning?
My lord, the only question is, the deceased had, the injured had no proof of income. In spite of that, the MSCT has fixed this income at 18,000 rupees. That is the only ground on which the appeal is.
All right, even if that is reduced and your is agreed, the entire amount what you have deposited, that can be adjusted.
Yes, ma'am.
Our learned counsel for the appellant and counsel for the respondent. Respondent has filed an application seeking withdrawal of the amount deposited by the appellant insurance company. Heard learned counsel for both parties perused the affidavit annexed to the application. Being satisfied with the reasons assigned or shown, the application is allowed. Respondent is permitted to withdraw the amount. Where is it deposited?
MSCT.
The tribunal shall disperse and release the amount deposited by the appellant in favor of respondent claimant by way of electronic transfer on respondent furnishing relevant bank details on proper identification. Is for admission.
90.
Much obliged.
Maheshwara S.
Yes, Maheshwara.
My lord, I have filed application for withdrawal of amount.
What are they questioning?
They are challenging on the quantum.
Only quantum? Maheshwara, Yellappa, Maheshwara.
One submission, my lord.
Hmm.
My lord,
Hmm.
that name may be deleted and B Pradeep name may be shown. S. Maheshwara is one of my senior, my lord. He is
Yaru?
no more, my lord.
Maheshwara.
Yes, my lord.
Ah.
That's purpose I didn't know the college still nodila name.
Ah.
Name delete ಮಾಡ್ಬಿಟ್ಟು B Pradeep ಅವ್ರ name ಕೊಡಿ.
All right. Leon, what is it questioned?
Quantum only they are questioning. They have deposited 50% of the award amount before the MSCT.
Allow this application.
Please, my lord.
Registry to show the name of learned counsel Pradeep B for appellant and delete the name of learned counsel Maheshwara. Yes.
Yes,
From the
Maheshwara.
cost list. I.e. 1 of 25 is taken up. Which is filed for withdrawal of the amount deposited by the appellant. Being satisfied with the reasons assigned cost shown. The application is allowed. The respondent is permitted to withdraw the amount. Where is it deposited?
MSCT.
The jurisdictional tribunal is directed to release and disperse the amount by your respondent claimant. By way of electronic transfer upon respondent placing so and so proper identification.
Much obliged.
Much obliged.
20. Kailash Shankar PS.
Why dispensation?
We have furnished the certificate copy in another connected matter.
Before this court.
Please. That is MFA 473 of 2025.
So we'll call it together.
Please.
Call MFA 473
3 of 2025.
473 of 25 along with this case. Production of certified copy, the judgment is dispensed.
I am filing a memo for dispensation against R11.
Notice to R1 is dispensed.
And issue notice to R2.
Issue notice to R2.
Syllabus 21. Kaveri Timaya.
I appear for the petitioner. If I could please request for a passover, my lord.
I can't oppose a passover.
I apologize.
All.
Please, much obliged.
Syllabus 22.
My lord, I appear for the respondents, my lord.
Lordship, I appear for the petitioner in the first matter.
My lord, I request passover, my lord.
Passover.
Much obliged, my lord.
Syllabus 23. Dismissal.
My lords,
Hmm?
lords, in this matter, your lordship was pleased to
4 and 5.
partly allow the appeal on the last, before last hearing date, my lords. And the respondent number 4 and 5 are the claim, parents of the deceased, my lords. They were not entered in appearance, so the matter was subject. Now, the respondents 4 and 5 have been represented by the compensation was enhanced from rupees 11 lakh 70,000 to 18 lakh 70,828.
So you are appearing for 4 and 5.
4 and 5.
Jagdisha,
Alla, BM Kinchegoda on behalf of
PM Kinchegoda.
Kinchegoda.
All right. So that amount will go to them.
Please.
So that was the only concern
Howdo,
of the
howdo.
court
Please.
because they are not parties.
Yes,
They are parties but not represented.
They are not represented.
The lordship was told that 10% amount may be ordered to be deposited in favor of
4 and 5.
Correct. 40% to appellant 1 and 2.
Please.
10% each to 4 and 5.
Please.
So that will continue. That's all.
That's all.
Yes.
So this can be now allowed. It's not shown as disposed of.
Yes.
All right. Learned Counsel Shri PM Kenchegowda has filed wakalat for R4 and R5. So they were the claimants before the tribunal?
Before the tribunal also, they are respondents, my lords.
Responded.
Yes.
But before the claimants.
4 and 5.
Yes.
So then. So here also they are 4 and 5. Please.
Yes. Before the tribunal, they were also placed ex parte.
All right. In view of the wakalat having been filed by respondent 4 and 5, that is the parents of
Deceased.
Same is taken note of and the appeal is allowed in part, ordered according.
Please.
Judgment.
Number 24, Sushmita Ji.
Here for the second respondent.
Yeah, so he's not here. Sushmita.
Smita Ji. 24, Ravindra P.
Have it next week.
When we refer to Lok Adalat, it says some
Quantum.
only on quantum.
Request of both parties matters referred to Lok Adalat.
For admission, cell number 25, Ashwin Yadav. C.R. Ravishankar, cell number 25.
My lords, in this case, I appear for the, my lords, last time, they had to verify the signature of that person, my lords.
Verify the signature of?
The, for the insurance company, my lords, the person who's done the accident, he had taken some time, so he's not here, we adjourned by a week.
Learned Counsel for appellant is present. Call this matter next week.
Cell number 26, Pawan Chandra Shetty, V. Rajshekar Reddy for R3.
For the appellants, my lordship. My lordship, in 26.1. My lordship, the notice may be kindly taken as deemed service, my lordship. Duly served, it may be kindly taken as duly served, my lordship. Because the postal shara shows that it is shara unclaimed, my lordship.
What may the postal shara unclaimed for whom? R1?
Yes, my lordship.
The postal shara of the notice issued to R1 is returned as unclaimed. Its notice to R1 is held to be served. It is deemed as served registry to show the name of R1 in the cost list. All after a week.
Much obliged.
Still number 27. Krishna Kishore, yes.
Krishna Kishore. A week's time granted if needful done, issue notice to R1 in MFA crop.
Still number 28.
MFA crop will notice.
Liability, my lord.
Huh?
My appeal is on liability.
Right, in MFA crop, R1 is notice ಹೋಗ್ಬೇಕು.
No, sir.
Your R2.
ನನಗೆ ಕಾಪಿನೂ ಕೊಡ್ಲಿಲ್ಲ ಅವರು.
All right, copy to be furnished to learned counsel for R2.
28. Mushtaq Ahmed.
I represent second respondent, madam.
Mushtaq Ahmed.
Mushtaq Ahmed. Or representation for appellant counsel for R2 present all next week.
29. Sarita Sharmi.
Yes, madam.
Case of injury, my lord.
Ready?
Yes, ready.
As Vijay Kumar.
Vijay Kumar, yes, sir.
T. Vijay Kumar. Pass over.
Please.
Number 30, Arjun. 31, Arjun, 32. Ramesh K.R.
Appellant in this matter, my lord.
30.
32, sir. V. Ramakrishna for R2.
Where is Ramakrishna? You're ready
Lord,
to argue?
32.
That is Ramakrishna.
V. Ramakrishna.
claim petition was dismissed, my lord.
Claim petition dismissed.
Dismissed.
Admit list for hearing.
Appellant.
Still number 33, Vijay Kumar T.
You notice to respondent.
34,
Shankar Reddy.
Shankar Reddy.
You notice.
Reduction of quantum, ready to deposit.
You notice shall be stay of operation of the order dated 22/8/24 MVC 528 of 21 by the additional district judge, MACT, Udupi, sitting at Kundapura, subject to the appellant depositing 50% of the award amount before the tribunal
Tribunal.
in 4 weeks from today.
35,
Manjunatha Rayappa.
Lakshmi Rayappa.
Manjunath Rayappa and Sridhara. 2 weeks time granted to do the needful.
Bill number 36,
Raghunath.
Raghunath V.
For petitioner, please.
For respondent.
To be permitted to file the compliance memo.
Arrears pending ಇದೆಯವರ
ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
I have cleared, my lord. The
ಕೊಟ್ಟಿದ್ದಾರೆ.
lordship can.
Copy ಕೊಡಿ ಅವ್ರು.
I'll furnish a copy.
ಕೊಡಿ. Give it to the court officer.
Please.
Give that, whatever you want to file. So you paid entire arrears
Yes, my lord.
till now.
Yes, my lord.
You deposited or paid to the account?
We have opened an account in minor's name, deposited the amount to her name only, my lord. I have placed the bank account and endorsement, everything, my lord. I have deducted what is being deposited during the pendency of the criminal petition. 88,000 being deposited, remaining 64,000 is deposited now, my lord. And January month, 14,000 we have deposited, my lord.
Now, the account which you opened, who's the natural guardian operating? there?
Mother, my lord.
Mother.
Yes, my lord. Yes, I have
Kindly
placed
give
it.
short date, my lord.
Hmm?
Kindly give short date. We will check and update.
Verify ಮಾಡಿ ಅವ್ರ ಎಲ್ಲ ಅಕೌಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ ಅಮೌಂಟ್.
Once respondent ಹತ್ರ check ಮಾಡಿ update.
Learned counsel files a memo for the petitioner files a memo. For having opened a minor account, the name of the minor child, and has deposited substantial amount as stated in the memo. Respondent to verify the same and make a submission. Call after a week.
37, Rudrabhushan C, Benakanalli. Abhinav R.
No representation on either side. Call next week.
Cell number 38, B group matter. Gita Devi MP.
Lots. We're supposed to produce the bank statements latest. If your lordships recollect, this had come up just last week.
It was adjourned for them to produce her
Yes, my lord.
present status.
Yes, exactly. Because he has apparently quit the job and joined some startup company where the pay is much lesser than what he was getting. Yes, that's right.
That is Gita Devi.
Kindly pass over, man.
Pass over.
Pass. My lord, so if is it before 1:30, then I will be able to. Otherwise, I have to take on VC because I have other matters.
Like,
so-
sir, could all.
Or tomorrow, my lords? Tomorrow, is that all right?
Tomorrow.
Please, my lord.
Request of learned counsel for the husband.
Tomorrow, my lords?
For the husband.
I'm for the husband,
husband, yes, my
Can
lords.
call this matter tomorrow. Yes, 25.
Great.
You are supposed to produce that
Please,
salary.
my lord, it is ready, my lord. I'll place it
Not
before your
salary,
lord.
bank.
Bank statement, my lord.
bank
Bank
statement.
statement. It is ready, my lord. Hence, I sought for passover.
39.
No, you can hand over the copy to her
I can
Please,
see,
ma'am.
yes.
and then come
that's fine.
tomorrow.
Please.
Great.
39, G.J. Sunkapur.
Sunkapur. No representation on either side. Call after 2 weeks.
40, Arun Govindraj.
Appear for the petitioner.
Counsel
for respondent, my lord. 2 weeks time, my lord. File detailed objection, my lord.
Lord, may I
Yes.
make this submission?
Yes.
Lord, an ex parte divorce is granted by the family court in the year 2019. Respondent has been served with notice, not once, on 2 occasions. She refuses notice. An endorsement is put up before the family court that she has refused notice. I lead evidence, divorce is granted. Thereafter, my lord, I get remarried. After my remarriage, she files a miscellaneous petition before the family court. Lord, the proceedings are pending for more than 6 years. I have a 6-year-old son. The family court says because the officer who put up the endorsement that the service of the notice was refused by the respondent, he has not entered the witness box and laid evidence. Therefore, the report of the court bailiff cannot be accepted and recalls the entire judgment. That is the only ground.
Yes.
Yes, my file objection, my lord, detailed. Only 2 weeks, my lord.
As far as stay of further proceedings, Lord, proceedings are still going on before the family court. The matrimony has been restored.
Now there is a stay granted.
No stay is not yet granted.
Where is your application? You're sought for stay.
Yes, writ petition. I've sought for interim order of stay of further proceedings.
Where is the impugned order?
But
Annexure.
the-
Annexure.
My lord, annexure P.
Annexure P, my lord, is the impugned order.
Page 196.
May I read?
So ex parte judgment secured by you has been set aside.
Set aside on the only ground that the court bailiff has not been examined before the court with regards to his endorsement that the respondent refused service of notice. Notice was served in 2 ways. One was through court, other was through registered post. Registered post has returned on both occasions, that she has refused. The postman, I cannot bring the postman before the court and ask him to read evidence on my behalf. It is not the requirement of the CPC also that the postman must be brought before the court. Order 5, Rule 19.
The divorce petition was filed by you.
By the husband, yes, by me.
So after that, you have got married now
I have got married. I have a 7-year-old son now.
from the second marriage.
Yes.
No, this was
First marriage,
filed,
there are no children.
No, this miscellaneous for restoration.
Was filed after I got remarried.
Now, after how many months? After the appeal period?
After the appeal, my lord, I got married 1 year after the decree of divorce was granted. 22/4/2019 is the decree.
Any other petition is pending between the parties?
No other proceeding is pending between the parties.
ಒಂದು ವರ್ಷ ಏನ್ ಮಾಡ್ತೀರಿ ನೀವು? After he gets married, you come and file, and that is it. Has to be heard. Heard.
Tomorrow, my lord, ready, my lord, argument.
Heard learned counsel for the petitioner. There shall be stay of all further proceedings in MC 4444 of 2018. File of the family court. Hello. So that has been revived, and that is going on.
Please. That is going on now, Lord. The MC is going on.
And the impugned order dated 31/7/2024 in miscellaneous 58 of 2020 till next date of hearing.
Obliged.
All right, you can argue. I'll stay that order. You can argue. This has to be heard. You can address arguments. 2 weeks.
Yes. Obliged.
Number 41.
Vagesh.
Vagish, yeah.
Yes, Madam Vaishali.
Matter where the matter is set down for orders, when they, after evidence, they find this application for amendment of written statement. And they want
That is
to.
a legal point that was involved.
Yes. No, the legal point is what, in her own evidence, she has stated that I have produced the copy of the evidence, wherein she has stated that he has left the house and we had no, the marriage was irretrievably broken down and we had no contact at all. I mean, he's only talking about intimacy. That's the only thing that he wants to include. It's not, her own evidence says otherwise.
What her evidence is?
I have produced it, Your Lordship. Your Lordship may kindly take page 82. Paragraph 8, 6 onwards. Now, the crux of the matter is whether as on the date of filing the petition, that is 28/2/2015, whether they were living together as man and wife.
No, that is admitted by you.
No. Admitted in the sense that she's in the house, yes.
Yes.
But not, they want to say, Your Lordship may kindly see her allegations that he was continuously intimate with me and therefore the question of cruelty will not arise. Now, her own statement in evidence. She's page 85, paragraph 6. I submit that though the parents of the petitioner and his sister were.
The pagination is not. Page 85 is paragraph 19 and 20.
Your Lordship may kindly take WP 522 of 2025. Objections, not the writ petition, the objection.
Let him also come then. Pass
Please.
out the matter.
Very well.
Because he'll also have to reply to whatever you say.
Please.
According to you, it's a legal point which he can urge before the court.
No, there's no question. No, he has urged it and it has been rejected.
What? The IE?
The IE has been rejected.
No, I'm not on the IE,
Please.
madam. What he's seeking in the IE is a legal point which can be argued.
Yes. That he can argue on the main.
His contention is that you have filed a petition, even according to you, both of you were living in the same house.
Please, in the quarters.
According to him, he had intimacy. According to you, there was no intimacy and apart from just staying under the same roof.
Same roof, and this gentleman, the respondent, had left the house 10 days earlier. In fact, a complaint was filed by his parents. Such was a harassment that he had left the house, which has come out in evidence, and the parents filed a missing complaint. Then the police summoned him. That's when he came back. And he.
So if you have his number, you can call him, we'll pass over the matter.
Please, Your Lordship.
Pass over.
If you are for the petitioner.
42.
Yes, ma'am.
42.
I am for the petitioner.
Ah.
Your Lordship has granted the interim order subject to payment of
I am
rupees 5,000 per month.
I have paid the entire amount arrears of maintenance to the respondent before the court below.
My objection, my lordship, there, he has not paid any single penny, Your Honor.
Madam.
This honorable court has directed.
Madam, order sheet 15 months arrears ittu, ella payment ಮಾಡು.
Yes, Swami, she is before this honorable court, Your Honor. As per her instruction, I am.
I got the order sheet, my lord, of the trial court.
What is the arrears you have paid?
75,000, my lord. 75,000 is the total amount.
ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೇವೆ?
ಅಲ್ಲ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಕೊಟ್ಟಿದ್ದೀವಿ, ಆರ್ಡರ್ ಶೀಟ್ ಇದೆ.
Swami, ಮೊನ್ನೆ 25,000 ಅಷ್ಟೇ ಕೊಟ್ಟಿರೋದು. But as per the direction of this honorable court, he has to pay every month 5,000 something. He has not done. He has not compiled this.
ಒಂದ್ ನಿಮಿಷ, ಸಾಹೇಬ್ರು.
Arrears ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ.
Why?
Totally. Madam, what he says is.
ಆರ್ಡರ್ ಒಂದು 25,000 ಪ್ಲಸ್ 50,000, 75,000 ಕೊಟ್ಟಿದ್ದೀವಿ. 2010 ಇದು ಅಕ್ಟೋಬರ್ 2023 ಇಂದ
ಕಾಪಿ ಅವ್ರ ಹತ್ರ ಇದೆಯಾ? ಕಾಪಿ ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ?
ಇಲ್ಲ
ಇಲ್ಲ,
ಸ್ವಾಮಿ,
ನಾನು
because
ಬೆಳಿಗ್ಗೆ ತಂದು ಕೊಟ್ಟೆ.
maybe
Your
2
client
days
is-
back only.
Your client is nodding the head. Your client is nodding her head. She must have
Yes,
received.
she has.
You take instruction, file memo of calculation. If there is any arrears, we'll direct him to pay.
Much.
Learned counsel, the petitioner submits he has deposited the arrears of maintenance amount before the family court.
ಡಿಪಾಸಿಟ್ ಅಲ್ಲ, ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀವಿ, ಪೇಮೆಂಟ್ ಮಾಡಿದ್ದೀವಿ.
Handed over to the respondent before the family court. Respondent to verify, file memo of calculation. If any, call this matter next week.
Much.
2 weeks.
2 weeks.
2 weeks. You find out if there is any arrears, you find.
Acha.
Yes.
Pastor matter still number 21.
On behalf of the petitioner.
For the respondent, my lord.
My lord, sorry, I was on my legs. I could not be present in the first round. My lord, now this petition has been filed by me, my lord, against an interim order passed.
Before that, sorry for the
Annexure
interruption.
A.
Lord, this was argued on the previous occasion. My lord was pleased to grant me time to argue on my IA, that's IA number 2. I'll make my submissions on that IA number 2. Thereafter, you can reply to that.
My lord, IA number
Because it will be, we are taking the my lord, case out of the track. So therefore, my lord was pleased to peruse the prayers made in IA number 2 by the respondent.
Your lordship may kindly see, I am for the petitioner. My writ petition is limited to annexure A visitation right. He wants to file an application for going abroad and all. Last time only we made a submission, my lord. This is not a family court. You go there, make the application there. I will be heard, you will be heard, whatever orders will be challenged. That cannot be filed here, my lord. We can't convert this court into a family court. IA number 2. It is not filed. It is only against an interim order passed in my favor, my lord, which we have called in question in this writ petition, annexure A. That is the impugned order. Your lordship is deciding on annexure A, not on the merits of the case, or original proceedings are still pending. There is no stay order. He can file that, he can prosecute that, we can contest it in family court, my lord. There is no stay of proceedings also. Kindly see, my lord, we have the petitioner before your lordship, my lord, has filed a petition for divorce, my lord, and for custody, my lord.
Why should I be
Impugned
deprived of
order, my lord,
my
is at
liberty to
page
make
number-
submissions to your lordship, my lord? I should not be deprived of my lord to make my submissions before your lordship, my lord. Last time, all these submissions were made. My lord was pleased to hear both of us on those counts.
Now
Lord, I
the
think-
question is the petitioner who's come before this court.
I fully agree with all the.
Let me also understand. I think you have read your file. I have not.
I'll
Let me also
make
understand.
submissions, but I'll make.
So now,
Firstly, the petitioner filed a divorce petition in Bombay.
who's the petitioner?
Petitioner is the husband against the wife. Then in terms of the orders passed by the Honorable Supreme Court, the petition was transferred from Mumbai to Bangalore. It is pending before the family court, which are not, facts are not in dispute at all. Now, the only question that is, that arises for your lordship's kind consideration is, in terms of the objection filed by the petitioner to my application, seeking your lordship's kind permission to alter the visitation rights and permit me to go to England, take my son also to England. That's the simple question that's now involved in my IA number 2.
In your IA.
In my IA, my lord, it's for my lord to consider on the basis of the submissions to be made by the wife, whether he can take the child by modifying the visitation rights. That's the simple question.
But that is not the writ petition. That is not in the writ petition.
No.
No, I do agree, Madam. I do agree. I do not say that.
So you're also admitting the fact.
Yes, yes.
You're also admitting the fact
Please, Madam,
that
please,
your
Madam.
IA is nowhere concerned to the writ petition.
No.
Not nowhere, my lord. My lord, the writ petition after being filed, there is no interim order of the further proceedings pending before the family court. Then each time, just before the commencement of the vacation, for the last 3 years, my lord, custody orders were given during the vacation. So there is no interim order passed, my lord, in the writ petition with regard to the proceedings.
What is the order that is questioned here?
My lord, the order that is questioned is the visitation rights.
Where is that order?
Annexure A, page 29, that's what I was making myself. I am the petitioner. If he can just have some patience and allow me to convince the court.
No.
Let him have his patience.
But
Every time, I do not understand this. It's my duty.
I do agree.
I am the
Let
petitioner.
me understand what the petition is.
Petition is what it is.
Please,
Where is the
please.
question of making these as if we are before a family court and we can't behave like family court lawyers
You
also.
make your submission. I
Yeah.
will hear you.
That is, let him have his patience, my
That's
lord. He
all.
must learn.
That's all.
Because, my lord, now kindly see, let me explain slowly, because your lordship, like rightly said, your lordship has not read the file.
I don't read the.
Read the file. That's a good habit, in fact, my lord. In my opinion, that's a very good habit not to read the file and come with an open mind to the court. Very few judges can do that. Anyway, my lord, annexure A is the impugned order.
Yes.
Petitioner before your lordship, my lord, is the husband. Respondent is the wife. Now, my lord, only the petitioner has filed a petition for divorce and under the Guardian and Wards Act to be appointed as a guardian. Wife has not filed. She had filed and she has withdrawn. So the question now for the family court is whether a divorce should be granted on my petition and whether I should be appointed as a guardian. Because that is the only question. I may fail or I may succeed before the family court is another aspect of the matter. Your lordship, don't even have to trouble yourselves on that. During the pendency, as it is usual, my lord, I as a father, am entitled to visitation right. Nobody can deny my visitation right, my lord, especially, my lord, there are a number of Supreme Court citations also, which I will cite on that. What happened? I filed an IA, my lord, for visitation right. It is allowed, but in what condition, your lordship may kindly see is annexure A. Not that it is rejected. Now, kindly see the order, what impugned. I will not read the whole order, my lord. Yes. Page 29 is the impugned order, annexure A.
Yes, 37 operative portion.
Yes, 30, exactly, my lord. I was coming to that. No, it doesn't matter. 37, his lordship is right. 37, my lord, is the operative portion. Where is it? 30 is the operative portion, my lord. Ink page 30, your lordships may get it.
30?
Yeah, 30. What? My lord, I filed a separate memo with all orders. Your lordship don't have to trouble yourself. Kodi, madam. On separate memo with all orders. So your lordship did not have to keep on shunting between the papers because there are about 9 orders passed by this court. This is the memo. This and I have a copy on the other side. All orders are in this, my lord. Your lordship don't have to trouble.
Yes, sir.
Take the trouble. Page 30. This is the impugned or part of the impugned order, my lord. It starts from page number 29 onwards.
Yes, sir. Yes.
Now let me take your lordship directly to page 30.
Yes.
Since January 2020, my lord, this is during COVID period.
Yes, yes, yes.
Till today, pandemic COVID-19 is going on. And another virus came by name of Omicron. About 2 years due to pandemic COVID-19, classes were also going on through online and there is no freedom to the human being to move from outside the home. In such a situation, welfare of the children is also important. Presently, respondent taking care of her child at her house, whatever it is. Therefore, in such a situation, visitation right of the first half vacation and also for celebration of functions at Mumbai is dangerous to the world. This is what he says. Their father has got right to meet his child. So, my right is not denied and there is no counter petition or counter appeal or a counter objection. So, this finding, my lord, that I have a right to meet the child has become final and conclusive. Meet the right. Therefore, it is just and proper to give a visitation right on alternative Sunday, 11 a.m. to 4 p.m. Alternative Sunday, 11 a.m. 4 p.m. visitation right. with some conditions in the interest of the child. Fair enough. Accordingly, petitioner is permitted to make a video call to the child in alternative days for 1 hour. Accordingly, I proceed to pass the following order. Sunday 11 a.m. to 4 p.m. till disposal of the main petition. Petitioner is permitted to make video call on alternative day about 1 hour. Respondent is directed to hand over the child to the petitioner on specific time mentioned above, and petitioner is directed to consider the likes and dislikes of the child. Further, petitioner is directed not to give ill advice about the respondent to the child while exercising. So this is the order which we are called in question on the ground, my lord. I, as a father, wanted 50% of the visitation right during the vacation. I have a right to meet my own child, and I wanted on every alternate meeting to come to Bangalore because I am a resident of Bombay. The respondent, who is a doctor, practicing doctor, is a resident, my lord, of Bangalore. I have to come all the way from Bombay on every weekend and spend a night with my child. These are all the prayers which I made in the application. Now, we called in question this, my lord, because this COVID was there, is no doubt. But the curtailing my right to meet my child, take my child to Bombay was called in question. Based on this, my lord, first order came to be passed by this honorable court, my lord, your lordship will kindly see, was passed after interviewing the child by this honorable court on 24/20/22. That page number 38. The first order. There are 9 orders passed by this court.
So that is after this order.
Yes, after this, in this writ petition which your lordship is hearing.
All right.
Now, what I am submitting is, my lord, that COVID situation is all past, gone history.
Yes.
That will not survive, my lord. The application of mine, now what this honorable court has done, by consent of both the parties can be made.
Where is that order?
The first order will be page 38.
Yes, 38.
The starting of the order is at page 37, my lord.
Yes. No problem.
Lordship Justice Pandit.
Yes.
24/20/22 was the first order, my lord.
Yes.
My lord, there in the middle, kindly permit me to read. Learned counsel for the respondent wife and then birth. In the middle. First para in the middle, page 38.
Respondent wife.
Counsel for respondent wife, referring to the statement of objection, submits the child needs guidance and help of the mother. As such, custody of the child should not be given. This is their contention.
Yes,
before this also there are certain orders, my lord, of the magistrate court in DB case, where the courts have come heavily upon the respondent and made observation. That also we have produced, that she is trying to prevent him from meeting. She is not conducting herself in a proper manner. She must conduct, because she is trying to act as if, my lord, she alone has the right, snatching that child, not allowing him to. All those observations are there. But this is the Honorable High Court first order in this writ petition.
Yes.
So they objected to give custody. Child may not be given for overnight. It is submitted that child is comfortable to spend time with the father under supervision of the mother. This was their contention, my lord. My lord, the child was called, his lordship justice interviewed the child, my lord, and then in the matter of child custody, first and paramount consideration is welfare in the interest of the child and not the rights of the parents. Custody, interim or final, has to be decided on its own facts. The child cannot be treated as a property or a commodity. The issue of custody of minor child is to be dealt with. This court, by order dated 12/4/2022, direct respondent wife to make available the child for interaction in the chamber. So, my lord, the child was interviewed by his lordship, my lord. He was interviewed on by order dated 12. Accordingly,
yes.
Accordingly, I had interaction with the child. During interaction, it is revealed that child is studying in first standard and after summer vacation, he would be attending second standard. Further, during the course of interaction, it was found that child likes his father. So there is no allegation against me or counter allegation about my relationship with my son, and this honorable court found that he likes me, mother. My child likes me, father, and he wants love and affection from his father. But at the same time, he stated that he would not be comfortable with the father without the company of his mother. Be that as it may be, father has the right to have custody of the child, and he has also got a right to enjoy the love and affection of the child. The child likes to have company of the father and has equal right to enjoy the love and affection. but at the same time, sentiments of the child is to be given due respect. In the circumstances, I deem it appropriate to grant visitation right to the father every Saturday and Sunday during summer vacation or the 1st of June 2022. This is the first one. On every Saturday and Sunday, I had the visitation right. Then, father is permitted to have visitation right between 9 AM to 6 PM on every Saturday and on every Sunday between 11 AM and 5 PM. The respondent is directed to hand over custody of the child to the petitioner father. At the same time, at the time stated above, Saturday, the petitioner father shall hand over the custody of the child in the evening at the time. Petitioner shall pick up the child from the place of the respondent and drop back the child to the petitioner father shall not take the child outside the jurisdiction of Bangalore Metro. Malad, this was the first order, Malad. Malad, let me make a submission, Malad. We complied with it and there is no grievance, Malad, that I obeyed the order. Not that I took the child or I didn't hand over or there was any trouble or anything like that. This is regarding number one, visitation right when I come to Bangalore. And this has been followed and there was no harm caused. This can continue till the disposal of the petition. How is it? Now, next comes regarding vacation, school vacation, whether a second order was passed by His Lordship Justice Dixit Malad on 21/9/2022, page 37.
Yes.
Malad, this is the order. I made the consolidated thing so your Lordship doesn't have to shunt through the paper.
Yes.
This court, again, Malad, His Lordship called the child, Malad, to the chair. This is the second time the child is interviewed. Now the child has grown up, Malad. He is about 10-year-old now.
10 years.
Young. The court has interacted. At present, the child is 10-year-old.
All right.
The court has interacted with the petitioner, father, respondent, mother, and the ward, who appears to be this kid going by its demeanor and interaction in the court hall. There are some not much unusual allegations against each other, which may merit consideration at the appropriate stage of the proceedings. That is not mean proceeding. Both sides, on the advice of their advocates, have agreed to the following arrangement. Now, kindly pause. This is by consent. Both of the advocates consented for this arrangement. So this is the first time they have consented, Malad, and this is a consent order, not even a court order. So far as the sharing of the child custody in the imminent school vacation. I want the same order. I want what you have consented till now, give it to me and let the petition be heard. That's all in my simple prayer. Let us read. The school vacation being scheduled from 24/9/2022 to 9/10/2022. In all, there are 16 available days, of which the first 5.5 days, child shall be with the father who has assured the court to conduct himself and honorable as is assurance given by the mother as well. So I have conducted, the mother also handed over. Both of us conducted honorably. Even the mother also conducted. Next note. The petitioner father has undertaken to the court and to the mother that the arrears of educational expenses of the child in Bangalore school on being vouched shall be shared equally by him in the respondent. That also we have come. So the second order also is complete. Both of us conducted ourselves in honorable manner. The child is also happy to spend the vacation with me, Malad, in Bombay. So the second order. Now let me come to the third order. Third order was, Malad, on 21/11/2022. Now here also the conduct starts. The fluctuation of the conduct of the mother starts because there is an observation here. Page 36. This is by His Lordship Justice Naga Prasanna Malad on 21/9/2022.
21/11.
I'm sorry.
21/11/22.
Yes, I'm sorry.
Yes.
I can correct it. Yes. The last portion of page 36, that para may kindly be taken.
Yes, sir.
Learned counsel for petitioner submit their certain rights as directed to the person court is frustrated by the respondent by not answering the call and directing the call should be made only at 6 AM or 4 PM, which runs counter to what the concerned court has ordered. In the violation start. She is somehow, I don't know why she starts violating the court order. We find contempt also. Therefore, it is needless to observe that the wife would cooperate for child for the cause of the husband in terms of the order of the consent court, failing which it would be construed that it is violation of the court order. That means it amounts to contempt. This is one order. Then the next order, my lord, is on 4/5/2023, page number 35. Consent order of occasion.
Yes.
So this is order number 4. Learned senior counsel appearing for the wife. Can you read that one?
Yes, sir.
Submits that the child is presently out of town and will be back on 12/5/2023. He submits that the wife would have no objection. Very similar consent again. For husband to take interim custody of the child from 13/5/2023 till 4/6/2023 for 22 days, mother. So I took the child to Bombay for 22 days. Why? Because of the consent, and this is the order number 4. One more order, 5th order again comes in, my lord. Take it. That is, my lord, at page 25/4/20. It starts at page 33, my lord, and the operative portion. It was a lengthy order, my lord.
Yes, sir.
Passed, but let us turn to page 35, para 10, my lord. So this is order number 5.
Yes.
Para 10, my lord. Third line, looking at these reports. Now what happened, my lord? Report. She is a doctor. Her father is a doctor. They started producing bogus, false doctor certificates. The child is not well, the child has got this, just to avoid. Which actually has been commented to by this court. This is what the court said. Looking at these reports.
That is a para number?
Para number 10, third line, page number 35, para 10, third line from the top.
Looking at
all these reports. That
yes.
Is she being a doctor, both she and her father are doctor.
Yes.
These reports, it appears that as rightly pointed out by the learned counsel by the father, that is, we ourselves pointed out, that all those reports are bogus. She is coming up with these certificates one after the other. Particularly certificate that is given by some Asha Kiran Children's Health Care Center and by pediatrician saying that child's screening time should be restricted to 60 minutes per day, shows that whatever the order she wants from the court, she is coming up with certificates one after the other. Like how, before your lordship, I want to go to England, I want to go to UK. How? How can I take the child out of the jurisdiction? Even the trial court has not even applied its mind. They want your lordship to permit her to take. This is exactly what she is doing. This is a certificate one after the other. Now, many certificates are going to be produced before your lordship, sir. The emails that are placed are of the year 2022, and the report of one Arjun Lakshmipati, whose qualification is not known from the report, is taken on. All the certificates to place before this court are not inspired confidence in the mind. Father is permitted to take the child, the impugned order. They prevented, they didn't want me to take the child. Yeah, 20-25 certificates are produced from different hospitals and this honorable court, it does not inspire confidence because the person who is given those certificates himself is not qualified. He is a doctor. He is misusing her position. Her father is a doctor. He is misusing his position. Call up to one of your colleagues, get a certificate from him. Now the impugned order. Father is permitted to take the child to Mumbai 1/5/2024 to 35/7 whole month. I was allowed to take. I took the child. Let me make one thing. There has not been one single complaint or affidavit or a statement that I have misbehaved, not conducted in such an honorable manner, not written the child on time, or I have violated anything, not a single whisper. So how to get at me? The best way of getting at me is coming up with this idea number 2. Now the next order number. Order number 6 passed by this honorable court. That is, my lord, his lordship justice. Contempt of court, one order was passed, my lord. Anyway, the contempt of court authority. And in contempt, again, she has been warned not to violate court orders. Then, my lord, order number 7, 19/12/2024. Page 2, my lord, we just passed on the order.
Yes.
Here again, they said Tengu, the court medical officer was called, whether they have fever or not. Kindly see all the drama took place, my lord. I'll read page 2 on 13/12. I'll just read from the first line.
Yes.
Senate counsel appearing for respondent submit the child is suffering from suspected dengue. Now, before number of medical certificates, opinions. Now the new thing is dengue. After the court has passed the order, then the said submission was recorded and the respondent was directed to hand over custody of the child to the petitioner by 14/12/2024 morning 10 o'clock, and the petitioner shall take care of the child and provide proper treatment of the child. Assuming a child has dengue, I am a father, I can also take care, I know how to take care of my child. So that's great. The petitioner and respondent have submitted medical records, and the same was forwarded to Dr. Jaishila and Dr. Wahid Khan, medical officer, High Court of Karnataka. After perusal of the medical record, was stated that in a suspected case of dengue, there will be risk for initial period of 7 days of fever, and later on there will be no risk to the patient, and hence they are of the opinion that if custody of the child is handed over to the petitioner, there will be no risk. So, High Court, court officer, not the medical officers come and give. Then the learned senior counsel so and so, appearing for the respondent father submits that that is he doesn't appear for father, mother shall comply with the pass this order, and this has reportedly passed interim orders directing the respondent to hand over custody. The next one, learned senior counsel so and so, appearing for the respondent submission. There is a function in the house of the petitioner and the respondent also, that is the wife also. I have no objection, she can come and participate, and that he needs custody of the child. Hence, this court, after obtaining opinion of Dr. Jaishila, Dr. Wahid Khan, that the medical officers of this one court, dispensary opined it would be appropriate and direct respondent to hand over custody of the child to petitioner on 21/12 morning at 11 for a period of 7 days, and further directed petitioner to take medical care of the child during that period. Thereafter, petitioner shall hand over the child to the respondent. I have done that. I took care of my child. We didn't have fever, we didn't have dengue, we didn't have anything. We had a nice time. I came and exactly on that day, 28th, I was in the child. Now, these are, my lord, the contempt. There is also a contempt of court filed, my lord, against her, where this Honorable Chief Justice and the bench has passed an order that if you behave in a scrupulous manner and all that, my lord, let us ignore that, my lord. It's all right. Now, my lord, so we are at this stage. Now, the main petition is pending. It has to be heard. There is no stay. We have not obtained stay. Anybody can go and proceed with the matter. So, interim custody, I am praying, my lord, because my application was disposed of with that observation. Keeping in mind, these are the 7 orders passed by the Honorable High Court, my lord. I am permitted to have visitation right of the child 50% during the school vacation. Weekend, my lord, on Saturday, Sunday, I'll come to Bangalore, visit the child and custody of the child, and I'll go back. That's all. That's all is my prayer, my lord. In view of these consent orders passed by the court, there is no harm in doing it, and the direction may be issued by your lord. Dispose of the matter at whatever, my lord, because you are also can't do any specific date in view of the Supreme Court decision. If the such directions cannot be given, as expeditiously as possible, or whatever. Because petitions are mine, they are not the petition. Now, let us now come to IA number 2 filed by him. Now, my lord, IA number 2 is not a modification. Kindly take
These
IA
facts.
number 2. One minute. Let me continuously finish. Now, his submission before your lordship.
You can't
was
dismiss
fallacious
the
and
case
wrong.
in the petition.
His application
By arguing on IA.
Your argument on your petition
is that
this.
That I have concluded that same 9 orders have been passed by this court.
So, as per these 9 orders, the courts have granted you visitation and custody during vacation
and function.
So that is continuing.
Continue. No, now again I have to make an application for every, instead of that, make a final order that whenever there is a vacation, I can take 50%, he can keep 50%.
So what was your application IA number 3? Where's your IA 3?
Page number 19, my lord.
Of the paper book or this one?
Of the memo, my lord, which I given. That was my application. Your lordship's got that, man?
Yes.
Can I read that, man?
Read that.
My lord, for the reasons stated in the accompanying affidavit, petitioner prays the Honorable Court be pleased to grant visitation right to Master Rayan to sought here under and ends of the to grant the interim custody of the child Master Rayan on every alternative Friday at 5 p.m. till 5 p.m. on the following Saturday. That's, my lord, the courts have given me number of times. Then to grant interim custody of the child on first half of summer vacation, Dasara vacation, Christmas vacation, midterm vacation. Because the court had refused, I had to keep on making application, and this court, after interviewing the child, granted me that prayer.
But nothing is perpetual as of now.
No, nothing is perpetual.
So it was only time period which was stipulated.
Exactly.
And that is followed by you. So your IA number 3 is not actually considered full as
It is
what
being
was.
disposed of, dismissed.
Huh? No,
Yes, disposed of is by refusing all these other things.
no,
The
no, it's
issued
allowed.
order,
It is allowed partly.
only partly, only part.
So that is what is challenged.
Challenge.
Let him say what is your.
And then I will start.
You can reply
Very
to
well.
that.
Highly obliged.
We'll see whether it should be considered.
Highly obliged.
Please, yes, sir. So no dispute on these facts which
Absolutely,
Mr.
absolutely no dispute. The only dispute, if at all it can be there, is some of the allegations are made. And I want to clarify one position that was held by the division bench in the contempt petition. I'll read from his records, only 2 lines about what the division bench had observed. My lord may kindly turn to page 44 of the notes memo submitted by the petition. Last but one page, last page.
44.
Please, ma'am.
Hmm.
Page 44, paragraph 5.2. I'll read only that paragraph.
Yes,
It may be true, may I read, ma'am?
yes, sir.
It may be true that the custody of the child was handed over to the complainant only on 17/5/2024, and the complainant handed over back the child to the respondent mother on 2/6/24 after consuming and enjoying the stay with the child. I'll pause here and will request my lord to kindly consider this. However, in the totality of facts and circumstances obtained, the court is not inclined to take a view that there is contempt, much less willful contempt on the part of the respondent to breach the orders of the court. So, it may be true that the anxiety of the mother to be with the child.
So contempt is dropped.
Contempt is dropped. So therefore, let it not be made a mountain out of the molehill. Parents do practice all such things, rightly or wrongly. It's an emotional part, which this court did take very kindly to that. Now, my lord, what is the prayer that is sought in IA number 2 is, I want to make it very clear to my lord that IA number 2 is not entirely
Yes.
IA number 2 is not entirely alien to the facts of the case or the prayers.
Yes.
But the essence of the repetition is the rights of the father for the custody of the child, which was granted not fully, which is now challenged before your lordship. So therefore, what this IA 2 does is that in case it is granted, it would alter the rights of the father for the custody of the son. Therefore, it is not that this is completely strange or it cannot be maintained here. But this writ petition has been pending for the last 3 years. And every time, just before the beginning of the vacation, applications were made. And as the learned senior counsel read out to your lordship, except once, at all times, it was a consent order. We have consented for the father to take the child.
Yes.
So therefore, now this it is not a ruse to keep the father out of the custody of the child that the respondent has filed this application, but she wants to pursue better opportunities in a different country, commensurate with the qualifications that she has that she possesses. So also, since the custody of the child has been with the mother continuously all through these 10 years, certainly there will be modification or alteration of the custody visitation rights. That does not prevent, that should not prevent the mother from pursuing both her career and the welfare of the child. Then, under such circumstances, what are the parameters or how such an application can be considered? Except the technical objection that it ought to have been filed in the family court. Now it's filed for your lordship in this writ petition filed by him. This is a purely technical aspect and a procedural aspect. My lord is fully aware that procedure is only handmaid of justice. Ultimately, what should weigh with this honorable court or with any court for that matter is in the facts and circumstances and the stage of this proceeding. What should be considered in favor of or against whom? That, my lord, is the discretion of my lord. And whatever order your lordship would be pleased to pass, my lord, graciously we'll accept that.
You have no option.
Maybe, my lord. But my lord, why I want
You
to,
have, you can challenge it.
that's a different thing. That's a different thing. But why I'm making this submission is, as alleged by the petitioner, it is not a ruse to deprive the father of the visitation rights. The visitation rights of the father in a modified form can be kept intact. And I will give my undertaking that the visitation rights that are going to be granted by this honorable court after if my IA were allowed, will be kept intact. The father need not have any anxiety about that. One of the primary reasons that the wife thought of leaving Bombay and coming to Bangalore, because I can make 100 allegations against him, he can make 1,000 allegations against me. I'll not make any allegation. But my lord may kindly peruse only one document sent by him. My lord, they are a very wealthy family, no doubt about it. They have got mills, factories, hundreds of crores of business, only son with his mother and sister. All may be fine. However,
Petitioner.
Petitioner, please. Petitioner. He did not comply with the orders of this court even to pay 50% of the son's fees in the school. In spite of that big fanfare about his love and affection to the son and fighting for his rights of custody. I'll not make much of that. I was living in a 5-bedroom house, a palatial house. Which another 5-bedroom house is in Bangalore also, which is kept in lock, and they don't want me to stay in that. And his son also, they do not want the son to stay in that. But I was invited to go back to Bombay and stay in a slum area of 250 square feet. That's the document I have produced. My lord may kindly peruse that document. Page 10 of my IA, document number 1.
Page 10.
Page 10, please.
Email.
My lord, get it, my lord?
It's an email. Email.
It's an email sent by my husband, that's the petitioner, to the respondent. Dear Shivani, this is to let you know that I have found an apartment in Century Mill, MHADA Tower in Prabhadevi, and I have signed the leave and license agreement from the 1st of May for 11 months. As in the past, we have had several issues with staying with my mother, grandmother, and sister. I am hoping that living in a separate apartment will ensure peace and happiness for our family. Please let me know when you plan on returning from Bangalore, as I can arrange to take you to our new apartment. Hope that living separately from my mother, grandmother, and sister will be a good solution for you. I miss Riyan very much and request you to make him face-to-face stroke WhatsApp video call with me every day, anytime regards, so and so. Well, next page, you can see. This MHADA scheme is what is that? Document number 2. Location plan, salient features, name of the scheme. Project location, Standard Mill Appasab Marathe Marg Prabhadevi. Type of the scheme, housing for mill worker and transit tenements. Total number of tenements, 107. Carpet area per tenement, square feet, 225. Blood, I did not accept that offer, go there, that's a different thing. But this will be sufficient for my lord to draw the conduct of the father, inviting his son to stay in a 225 square feet small place in a slum area, which is built only for some slum dwellers. So therefore, I thought that myself and my son may not be very happy in that environment. He shifted to Bangalore. Now he is admitted to a good school. Father is directed to pay 50%, which is not paying promptly. That's a different thing. In spite of they being so rich, in spite of they having a house, a palatial house in Bangalore itself, which the document number 3 may kindly be seen. It's of course in his mother's name. That's a different thing. For the sake of his mother, he wants to keep it separately.
But all these are all on the merits of the matter.
No, that's what meant. No, the reason is merits of the matter. Yes, I do consider. I do not say that without considering any of the submissions that are now made by him. Only my application should be considered. As he has taken your lordship through certain records, I also want to assist your lordship through these records to show that how I am entitled or how I can persuade my lord to grant me the relief. Only for that limited purpose. And my lord, the father in spite of knowing that the son is admitted in a school in Bangalore, admits the very same son to some school, and he goes and sits in the place of the son. Maybe out of genuine love and affection for the son, or to remember the son, he wants to go and sit in this place. But a sane person with sanity of thoughts and behavior, well, could he afford to do that is a different thing, and I leave it to my lord. It's the photograph of the father. He sits in the place of Rian Segde in the school. So, well, this is the background when I thought that with the educational qualifications that I have, and to forget all the trauma and suffering at the hands of husband or his family, whatever, or it may be my mistake also, that's a different thing. Let's not go into that. I thought of appearing for the examinations. I did appear for the examinations conducted by the London authorities. I passed in all that, and I got an offer. And my invitation from the British government or institutions in Britain will last till the June of this month. That is the reason, or I requested my lordship's kind indulgence to hear me on this IA number 2. What are the benefits that the mother and the son will get in a distant land, as they've stated, in a foreign land? Yes, that may all be true. But there is another positive side to the career of the mother and the educational opportunities of the child. That I have narrated. I will not burden your lordship with all the details. I have stated everything in the application. Now, my lord may kindly permit me to make a submission that what is the position in law that is laid down by the Honorable Supreme Court in such circumstances where two mothers wanted to take the child out of the country. The first of the two judgments is, my lord, AR 2010 Supreme Court, Vikram Veer Vora, Shalini Bhalla. I'll not trouble your lordship to read the entire judgment. The mother wanted to take her son to Australia. That was granted. My lord may only consider paragraph 16 and 23.
Now the question is,
please.
All these cases, I don't think so. These applications are filed before the High Court for the first time.
No, my lord. But
I don't know. I have not read it.
No,
but
no, no.
I'm asking you.
I consider that.
I'm assuming.
Yes,
That none of these applications would have been filed in the High Court.
I do concede that there were certain proceedings before the trial court. In one case, the order passed by the family court Bangalore was not challenged. In spite of that,
Maybe so. I'll cut you short. Sorry for that.
Please, please.
I will direct the family court to consider application within a week's time.
Oh, my lord, that may also be possible, but before that, my lord may kindly consider only reading these two paragraphs.
No, even
that is,
see what you are saying. I am not disputing, and that's why I asked you this very first question.
Yes.
As to whether
my lord is fully right. My lord is fully right.
So if that is the case, I will direct the family court to consider your application IA number whatever 2 you have now filed.
2, please, ma'am.
Same application or a fresh application, whichever you want.
Please,
place more materials.
Please.
Go before the family court, argue the matter. It will be decided in a week. The family court may grant you. If it does not, you are also.
I have to come back to this court, and my lord, after the proceedings in this court, which my lord is very kind enough and gracious enough to say that, my lord, it can be disposed of in 1 week. But the same thing cannot be said about running away from the jurisdiction of the Indian courts. That's the reason why, my lord, candidly I made this application. If I had some other ulterior motive, without telling anybody, I could have flown off to England or made some other arrangements. No, intentions are fully genuine and fair and transparent. My lord may kindly appreciate my fairness in the form of filing this application.
No, the question is now you are going to UK.
Yes.
He may not have objection. The
No.
wife going to UK, he will not have any
That's
objection.
a different thing. To
It is
take the child,
immaterial.
to take the child,
child,
to take the child.
considering these facts of what he has now argued,
Yes.
he may certainly have objection. Because as of now,
He's bound to have objection.
yes.
Whether his objection can be sustained or is it tenable is the question to be decided by my lord.
No.
And now, my lord, so far as the option of remitting the matter back to the family court, I have got only one submission. Since at the beginning, I made a submission that procedure is only a handmaid of justice. But where to file an application during dependency of a case before the High Court is only a matter of procedure. My lord, if the larger interest is and the justice is considered, my lord can certainly entertain this because having my lord seen my lord is pleased to peruse different orders passed at different times in this very proceeding. So this IA can be considered in this very proceeding is my humble submission. Therefore, I read only 2 paragraphs in this so that my lord, if I can try to persuade my lord. Paragraph 16 may kindly be seen. So far as the facts are concerned, the paragraph 2,
Yes.
paragraph 2 of this judgment. This appeal by the husband.
I have read that already.
Please, grateful to your lordship. Then, my lord, para 16. Para 16 on page 4. May I read, my lord?
Yes, sir.
In a matter relating to custody of a child, this court must remember that it's dealing with a very sensitive issue in considering the nature of care and affection that a child requires in the growing stages of his or her life. That's why custody orders are always considered interlocutory orders, and by the nature of such proceedings, custody orders cannot be made rigid and final. They are capable of being altered and molded, keeping in mind the needs of the child. Then, my lord, paragraph 23. Now coming to the question of the child being, sorry, may I read, madam?
Paragraph number
23 minutes, 2-3.
Yes.
Now coming to the question of the child being taken to Australia and the consequent variations in the visitation rights of the father. This court finds that the respondent mother is getting a better job opportunity in Australia. Her autonomy on her personhood cannot be curtailed by court on the ground of a prior order of custody of the child. Every person has a right to develop his or her potential. In fact, a right to development is a basic human right. The respondent mother cannot be asked to choose between her child and her career. It's clear that the child is very dear to her and she will spare no pains to ensure that the child gets proper education and training in order to develop his faculties and ultimately to become a good citizen. If the custody of the child is denied to her, she may not be able to pursue her career in Australia, and that may not be conducive either to the development of a career or to the future prospects of the child. Separating the child from his mother will be disastrous to both. I'll conclude this submission. And the petitioners, she was permitted to take the child to Australia.
How old was the child?
Where is pardon?
How old was the child in this case?
10. 8 to 10. The court considering the fact that the child who is about 8 to 10 years. That's similar in the first page. In the head note.
Yes.
8 to 10 years.
Yes.
Where the next is a recent judgment of the Honorable Supreme Court, 2023. Well, this is also, in this case, the order passed by this Honorable Court was challenged before the Honorable Supreme Court, denying the rights of the mother to take the child out of the custody of Bangalore Court, Family Court. Paragraph 9.5 and 9.6 may kindly be seen. 9.5.
Yes.
May I read, madam?
Yes, sir.
The paramount objective must be to ensure the welfare of the child. The child has been in the care of the appellant since his birth, and the parents of the appellant shifted from Noida to Bangalore to help her. The appellant was even ready and willing to bring the child on every third Saturday for grant of visitation to the respondent as directed by the family court, should this be so ordered and directed by this court. Then, the appellant and her son hold Indian passports, and the appellant is willing to furnish such an undertaking as this court may direct to ensure that the child is not placed outside the control and jurisdiction of the family court, Bangalore. Mrs. Arora has urged that the appellant was constrained to move out of the jointly owned residential apartment due to the violent and abusive conduct of the respondent, and the reason for her to seek the permission of this court to take the child to Singapore is to enable her to look after the child. It has been submitted that the employer of the appellant, which is not relevant. Then, Mullan, paragraph 18, which is this is a submission made on behalf of the mother to take the child out of the country. And the finding of the court is recorded in paragraph 18. In matters such as the present, the welfare of the minor child is of paramount concern. The jurisdiction of this court under Article 142 of the Constitution is a facilitative constitutional instrument to advance subjective judgments. In excess of these parts, we are of the view that the arrangement which has been arrived at during the pendency of the proceedings should be modified so as to best subserve the interest of the child. What is I pass here and read with this sentence of the Supreme Court with emphasis. The technicality of whether or not the appellant has challenged the family court's order dated 1/3/2018 cannot obfuscate the core issue, which is the welfare of the child. Allowing this case to be lost in the maze of technicalities involving a formal challenge to the order will eventually lead to the child staying in Bengaluru with the maternal grandparents while the mother is employed in Singapore. The child will lose a year of education in Singapore, which is an additional reason for the exercise of the jurisdiction under Article 142. We have informed that Singapore is COVID-free and child would be able to attend regular school and some online classes. Undoubtedly, they responded. This and the court passed the order. Paragraph 20 and paragraph 20.1. The impugned judgment and order of the High Court dated so is set aside. But several conditions are laid down. My Lord may kindly record my undertaking that all the conditions that were imposed by the Honorable Supreme Court with regard to their visitation rights of the father, the jurisdiction of the Indian courts, and any time the child to be produced before the court, I undertake, madam, in terms of the order passed by the Supreme Court only. So therefore, the reason for my going to family court, file an application fresh or considering this very application, coming back to the High Court will entail the loss of valuable time. That is my submission, madam. My Lord is certainly right in directing me to go back to the family court. I don't contest that. But my Lord, because of the urgency, my Lord may kindly exercise the discretion and my Lord,
So who is residing with you?
pardon?
You are residing, anybody is residing with you? The mother?
Me, my father, my age-old father of 75 years, who does not regularly practice medicine now because of his age and also health issues. And my one sister who is unmarried.
They are residing with you in Bangalore?
In Bangalore. It's my father's house. It's not with my house, man.
Oh, the petitioner is in Mumbai?
Petitioner is in Mumbai.
Mumbai.
But one last submission, my Lord may kindly consider, with regard to sending me back to the family court to comply with the necessary formalities of the hierarchy of the courts. That is, it's basically a matter of procedure. It is not that High Court is prevented or prohibited by any provision of law. That it shall not consider such an application in a pending writ petition filed by the husband. But if the interest of the child is paramount, whether the petition is filed by the husband or the wife, doesn't matter much. That should not take away the opportunity that has come now. Is my humble submission.
What is the opportunity?
That I have an offer to go to England for employment. And
no, that offer, he is not objecting. I don't think he is objecting your offer to travel to UK.
But should I leave the child? But as the Supreme Court was pleased to observe, that mother should not be made to choose between her career and the taking care of the child. That's precisely what I am positioned with now. If my lord, the contention of the husband is accepted, he wants the child to be left behind in India and I have to proceed to England for my career. Well, he may be right in saying that, but should that be done? Since the Supreme Court time and again has said that the paramount interest is of the child. The interest of the child will be subserved better if the child is with me because of the age. Once the child attains the age of majority, he can very well come back to the father and stay with him. That's a different thing. And that also
means he will not be coming and seeing the father till he attains majority?
No. Visitation, that's why I said, once in a year or twice in a year, visitation rights of the father for 15 days or whatever leave that will be granted will be ensured. That's what the Supreme Court has done. That same thing can be done here also. It's not that I want to take the child away completely from the custody of the child when custody of the father till he attains 18 years.
Which school the child is presently studying?
Aditi Malya in Yelahanka.
It's a residential school?
No, Malya.
Mother is staying in Bangalore.
The child is staying with the mother.
All right.
And he is given an award. Your Lordship, the learned Senior Counsel was fair enough to read that order of the order passed by this Honorable Court. That is a whiz kid. And he has studying in the second standard. He was awarded the prize, which where even 7th standard students also had participated in the contest. He is a very intelligent child. And the father can bring up the child, it's not that. But having been with the mother for all these 10 years, suddenly to take, it's like taking fish out of water. Visitation rights of the father can also be maintained. An equilibrium can be maintained with the visitation rights of the father, the future of the child, and the career aspects of the mother. Is my humble submission.
So it is not your case that the father is not taking good care of the child?
I'll not make any submission on that matter. At this stage, it's not fair on my part to make any submission and vitiate either the process of consideration of my application or any submissions to be made, though very strongly, and I'm not as strong as he is in a later vein. I don't want to jeopardize the application's consideration. I'll not make any submission on that.
All right.
So now, my lord, with regard to the technicality, which can be kept aside.
Yes.
If the larger interest, the latest judgment, there are several judgments on that aspect, but I'll read only paragraph 23 of the 2024 latest judgment, which is the judgment against the order of this Honorable Court of confirming the order passed in this Honorable Court. Paragraph 23.
Para 26.
Para 23,
3.
Yes.
Yes.
It's well settled that rules of procedure are intended to be a handmaid to the administration of justice. A party cannot be refused just relief merely because of some mistake, negligence, inadvertence, or even infraction of the rules of procedure. I stress this sentence, infraction of the rules of procedure. The court always gives relief to amend the pleading, but that's on the merits of the case. Here in this case, the facts may be slightly different.
That was for amendment of the pleadings.
That's the amendment of the plaint. And the question that was raised was, the High Court did not frame a question of law, substantial question of law in terms of section 100 of the CPC. Therefore, that judgment was wrong. So that's why the Supreme Court observed that the infraction of the rules of procedure. This, my filing an application may, even if I were to concede, that it may amount to infraction of the rule of procedure of going to the family court first. But because of the paucity of time, I can't request another bench of this Honorable Court when it comes after the order passed. If it goes in my favor, certainly he will challenge. If it doesn't, or I'll have to challenge. I can't plead this as I'm pleading to the generosity of your Lordship, that the time is very short, and therefore kindly consider this application. Is all my humble submission.
But as of now, even according to you, you have not got any admission to for the child in UK.
No. How can I do that, my lord? I will, without taking an order, I didn't want to do that. Therefore, I have not done that. Arrangements are made. Once I get an order passed by this Honorable Court, or a judicial order, where I can rightfully go and get my child admitted, I didn't want to do that. Therefore, I filed an application. That's all my submission. Grateful to your Lordship.
Yes, sir.
It is not that as if your lordship passes an order that will become final, as if we can't channel that in the Supreme Court. It is not a matter of procedure, it is a matter of jurisdiction. Now, the citations which he himself has given, let us, for example, take the second citation. Ritika Sharan. Kindly turn to, your lordship's got that one?
Yes.
Para 3. Where is the application filed? Where is the jurisdiction? Original jurisdiction is family court under Family Courts Act. Applicant filed IA number 3 in July 20 proceeding before family court. Then comes the next step is the Honorable High Court's order. You can't skip that and take away my right to approach your lordship in an appeal or in a writ. The crux of the point, your lordship may kindly see, my writ petition is under Article 227 of the Constitution of India. It is the supervisory jurisdiction under which I am before your lordship, not 226, where there is wide discretion to pass any order.
Yes.
Now, next is, kindly see, my lord, paragraph number, let us come to 18. Under what provision did the Honorable Supreme Court pass the order? Kindly see para 18. We can't read citations just like that, my lord. Every fact is important. Para 18, your lordship may kindly see. Very well. In the matters such as present,
Para 8,
welfare of
para 8.
Para 18, 1-8.
1.
That's how they exercise jurisdiction.
Yes, in the matters.
In the matter such as present, welfare of the minor child is of the paramount concern. The jurisdiction of this court under Article 142. This court doesn't have jurisdiction under 142. So what my learned friend has to do is file the Article 32 petition, direct Supreme Court. I don't want to go before High Court also. I don't want to go before Family Court. You give me direct order, so I don't have another appeal. If his arguments are accepted, I don't want to go. Who has stopped you? There is no stay order. We didn't prevent you from filing an IA. If that is great urgency, instead of filing here, why you did not file there? And that is the court under the Family Courts Act, which has the jurisdiction where any interim, he read, custody rights are interim orders are passed in aid of final. This interim order, is it going to be passed in aid of any final order? No. Your lordship is limited to seeing the interim order passed annexure, whether that is correct or not. That's all. And that too under Article 227. Hierarchy of courts is a matter of jurisdiction. It's not procedure under CPC. For amendment of plaint, you can amend here, amend there. That's not the case. So this is the second thing where they say under Article 142. Kindly see, my lord, you can't equate the jurisdiction of this court under Article 227 to Article 142, which is not applicable at all. If you are in such great urgency to go to England and whatever all merits he's been addressing, those documents, that is meant for trial court to see. Even evidence that has to be marked in evidence. I have to cross-examine. It has to be exhibited. It is not even an exhibit which can be produced before your lordship, like as if I produced from my pocket, look at this document. Go to trial and see all that. Even if you want to rely on that in your IA number 2, ABC is there in IA number 2. Put IA number 2 prayer. What is this IA number 2 prayer before your lordships? Is this in any way related to my prayer? Kindly see. If I can understand, don't give him weekly rights. That is why I made my first submission, my lord. There is no counter appeal. No counter petition has been filed, no counter. That is the first submission I made because I was anticipating all. If you wanted any modification in that order, which is already passed, if you are agreed, you should have filed a petition or counter petition. That is the proper mode. Now let me see his prayer. Give the passport of minor child master Riyansh to respondent. Can this court direct that under 227 when the matter is not yet even heard by family court on merits? Then give consent to renewal of passport. How can this court do all that, my lord? Give consent for obtaining United Kingdom visa. So is this court about the consulate of UK saying you give them visa? Can this court direct? Well, these are all applications which are not even maintainable because no court in India, even Supreme Court can't give this decision. Under Article 142 to the UK consulate, give them visa. And passport is not your and my property, it's the property of the Union of India. Passport doesn't belong to us. Then give consent for any requirement from passport. How can your lordships grant these prayers, my lord? Are we sitting over the passport officers, over the consulate? It is ridiculous. It is ridiculous because this court does not even have jurisdiction, even if it wants to help him. Even Supreme Court doesn't have jurisdiction, my lord. Let my statement be recorded. These prayers can't be given even by the Honorable Supreme Court. Can the Honorable Supreme Court give a direction to the Consulate of UK? You give him visa. What if you are not qualified? It is within the discretion of the Consulate of UK. Go, apply. If they don't come back, file a writ petition. If your passport is not renewed, come back to High Court. That is regarding passport and visa. Does this court have jurisdiction even to entertain an application even if I don't file? One. Next is, my lord, hierarchy of court, interim orders, my lord, the first citation. Even in this first citation, this is the one. No, yeah, this is the one. Even this, my lord, is against an interim order passed by the. Even here, application is filed in the trial court, then High Court, then the Honorable Supreme Court. Come to that. His first citation, his first citation, which he cited, my lord, under Hindu Marriage Act, was the first citation. That is, my lord, 2000 AR 2010 AC 1675. Now let us see here also, my lord. In the instant case, that is at left side, my lord, bottom, in the head note, in the instant case, a divorce was granted by mutual consent. Divorce was already granted. The terms and conditions to custody of the boy child were contained in the petition for divorce for mutual consent. So only what they had agreed, if they don't comply, what was the order? And that too there, my lord, kindly see para 2 of the judgment. This appeal by husband impugns the impugned judgment and order of Delhi High Court, which upheld the judgment of the family court under section 26 of Hindu Marriage Act. So can you overlook 26 and say, I don't want 26, I'll come under 227. I don't want 227, I'll go directly under 142. You can't do that. Hierarchy of court, that's why only one citation regarding, I don't think I should be because it's agreed regarding hierarchy of courts, my lord. But still, good. Hierarchy of courts, which one you mean? Okay. Give to the court. Now, what is hierarchy of courts? It is not simple expression or term. Para 29. Can this court usurp the jurisdiction it is? It is not technical aspect, it is the jurisdiction is family court, para 29.
Yes.
I can understand if it is technical, hyper-technical, procedural, handmaid of justice, CPC is a handmaid of justice, because my lord, it is a civil procedure code. It is not civil procedure act. Why is it not called an act and why is it not called as a code? Because it is the procedural code which is exhaustive in nature. You can't look beyond that code. Therefore, it's called as a code, criminal procedure code. Why it is not called? And there are certain reasons. They are procedural, but still they are codes which are exhaustive. Here, it is under the Act, Family Courts Act. I have to go before the family court. If I want to file a divorce petition, I'll file directly under Article 227. I'm in a great hurry. I want divorce. I want to get married. I don't want to waste my time in family court. Kindly grant me divorce. Can I come? Because the Act says no. When Act says no, you go to the jurisdiction it is. That is why kindly see para 29. I have 2, 3, but let me just read this. It is difficult to appreciate the anxiety of the division bench of the High Court. Now, this is what he is asking your lordships to do. Anxiety, I want time. There is no time. Kindly pass orders. To dispose of the interlocutory application instead of relegating it to the court below for disposal. That is precisely I'm saying. Why should this court be anxious? There is no anxiety. And there is no stay. Why did you not file there? I can understand he had an impediment there in filing. Who prevented him? Even today morning, we go file it right now. We'll file objections. All your facts will contest. The Supreme Court citations will let the learned family court also hear what is your case. Then your lordship can appreciate as sitting as a higher court. I can't ridicule and reduce your lordship to a family court judge and bring all these things. Whether he's studying, he's got good certificate. Is this court meant to do all that? No. Kindly see, my lord. When division bench of High Court itself took 8-9 months to decide the appeal. Now, how many years is this writ petition pending? When the division bench of High Court itself took 8-9 months to decide, it is difficult to understand as to what the learned judges of division bench of High Court meant by unnecessary prolongation of litigation and utter wastage of time. That's what he wants your lordship to write. If it goes before family court, it's a waste of time. And had been never even be thought on those lines, my lord. Waste of time. If the learned judges of division bench were so much concerned with the prolongation of litigation, they could have very well requested learned single judge. Kindly see here, instead of single judge, your lordship will request the family court. Family court application within a stipulated period. That is what your lordship said. 1 week, and that is the correct procedure with due respect. What? Instead of waiting for a period of 8-9 months, this could have been done by them at the very first instance when appeal was listed. Well, when has he filed this application? See the date of it. Just to prevent, after all the 9 orders are passed in my favor, he comes out with this application. November 2024. When were those 9 orders passed? March before that. What prevented you from filing then? So he doesn't. The last order which his lordship Justice Kinigi passed, just before that he files his application because he did not want me to take the child to Bombay. It's only preventive. My lord, even if she's a doctor, the topmost surgeon in India, she will not get a job in UK because you have to pass their exams, they have to be invited, contracts will be there, and that too will be given for 2 months, 3 months, and she has to come back. Permanently, the Prime Minister is not going to invite her and give her citizenship and a job. It's not so in UK law. I know what the UK laws are. It's not so simple. Let me continue to read this, my lord. Yeah, this hierarchy of the trial court. Kindly see that word, my lord. This is what I've been arguing. The hierarchy of the trial court and appellate court exists so that trial court exercises its discretion upon certain principles of law. So it is not procedural, my lord. Hierarchy is created by the constitution of this country, giving me a right to appeal, giving me a right to approach a second appeal. Is a constitutional right, my constitutional right and procedural right, appellate right to come before your lordship. My lord, I have a constitutional right under Article 227 to come before your lordship and say, look, that order is wrong. So you want to take away my constitutional right of coming before your lordship? That's what he wants. Urgency. What urgency? Why are you sleeping here then? What prevented you? That's what the Supreme Court says, my lord. An appellate court, the hierarchy of a trial court and appellate court exists so that the trial court exercises its discretion upon settled principles of law. An appellate court, after the findings of the trial court are recorded, has an advantage of appreciating the view taken by the trial judge and examining the correctness or otherwise thereof within limited area available. Because, my lord, your lordship is not sitting under the original jurisdiction of a family court where I'm going to cross-examine. Supposing I file an application tomorrow, his documents I need to cross-examine because they're bogus. Can we set up a witness box, put him here and examine? Is that the role of the time? Here it is limited. That's what they say, my lord. Limited area available. If the appellate court itself decides the matter, required to be decided by trial court, there would be no necessity to have hierarchy of courts. We'll abolish family courts. We can even abolish High Court and go directly under Article 32. As observed by this court in so and so, the appellate court cannot usurp jurisdiction of the single judge to decide as to whether tests of prima facie, balance of convenience, these are made out or not. This is only one of the citations. I have other citations, but they're all the same. They repeat.
Not be required.
Not necessary. So, if your lordships what your lordships said in the first thing is correct. Go there, file there. And hierarchy of courts, my lord, is a constitutional this thing. It is not some procedural aspect saying that you ignore it. So IA number 2 prayer cannot be granted even by the Supreme Court, my lord.
No, he is not seeking visa authorities to grant visa. What he's seeking is a consent to give
Let the trial
passport.
court consider.
Consent of the father.
Even if I give consent, let us assume.
But he has very effectively misled it.
1 minute. Even if I give consent, visa can't be granted. It is for the authorities in to do. So let the trial court consider whether, supposing trial court says you give consent, I'll come before your lordship saying that it has no jurisdiction to say that.
Now, merely by consent given by either husband, father or mother,
you can't get.
Visa may be rejected by the visa authority.
No,
that is
what I'm
altogether
saying is
different, my lord.
my
That's
right-
altogether different.
Please, 1 minute, I didn't interfere. My right to come before this court, in case the trial court accepts and grants it, is the erroneous order. I'll come and point out, my lord, this is an erroneous order.
Yes.
So you want to take away my constitutional right of coming before this court Under Article 227. All. That's it. Oblige.
May I make only one submission? All this submission to drive me back to the family court is only to delay the tactic. It's delaying. It
Not driving. That is the original proceedings you should have gone.
By delay, what would he achieve is only his satisfaction that he has prevented me and my son to go abroad. That's all. Nothing beyond that. Whether this court passes an order, Supreme Court, yes, in that the second judgment of 2023, it's under 142. I don't deny that. That's why I read that. In fact, I did not skip that portion and read only the relevant portion of technicality. It's 142. But the previous judgment of 2010 was not under 142. I only read those two judgments to apprise your lordships as to what is the position of law that the Supreme Court laid down in cases where mother wants to take the child out of the custody of out of the country. That's all. But after all this, my submission is, if my lord for any reason feels that I should go back, as my lord, it's an alternative submission, as my lord was pleased to observe that the family court can be directed to dispose it of within this very same IM, since he has already filed objections and since no evidence need to be recorded, it's only straight case of giving or no giving, not giving. That
He has to file fresh IA in family court. This can't be transferred.
This attitude is not right, my lord, on the father.
That is the
on the
law.
part of the father. He wants to prevent me.
That is the law. Sir, that is the law.
What does he gain?
That is the law,
No,
sir.
he-
You
he-
can't take the writ petition and make it into an
You
IA.
can't take the refuse of law or the constitutional right to prevent the wife and son to go abroad for a better living. This is the nature of the father.
No,
And he,
I don't know whether it is going to be better living outside India.
India.
it's a different thing, but she wants to do that.
There is a misconception by most
But
most
one-
of the Indians
One more
that
reason.
by traveling to outside country, or either UK, Europe, United States of America, Australia, Canada, or UK, that you're going to have a great and better living.
No.
Not all. Many may suffer because I have my.
You're still going to be treated as second-rated citizen in any other country other than India.
India.
Simple
And
as that.
even as a tourist,
But of course, I agree with you that there is better quality of education, no doubt. But you will still be treated as second-rated citizen. You will still not be offered Oxford or Harvard. Please take it from me.
Not all.
even as a
not
tourist
all,
when we go.
Not all.
No,
Because in Canada, in one university where
They'll
the
give
minister of this country went, just about 6 years ago, of the 32 departments, 31 were headed by Indians.
Hmm.
Then the question was asked by this minister who interacted with me personally to find out as to how Canada can grant you so much. He said the answer of the professors was that here, unlike in India, things are decided on merits. People will be selected on merits. Just because somebody else is somebody's son, he or she will not get appointment like in India.
correct. That is true.
So therefore, and the reason for my making an application at this point of time is not as what he said. I did not complete my examinations. Only after I completed my examinations, I filed this application. Before, and it's a government job. So therefore, the matter must be viewed from the angle of all the parties, not from the angle of only a father who is very keen to prevent his wife and to go abroad. I may suffer or I may not come back.
It's not preventing you from going.
Constitutional right to oppose everything that I do.
No, he's not at all preventing the wife from going wherever she wants to go. He's only concerned about the
The
visitation.
Well, if it were only that much, I need not have filed this IA at all. Because I filed this IA to ensure the better prospects of my son. But the court may decide otherwise. I do not say that. My lord, also, we have seen just 15 days ago how Indians were chained and brought back because they were all illegal immigrants.
No, they were changed because they should not commit suicide in the aircraft. That is also another reason
It's a
because of
different thing.
depression.
See,
There
but-
are reasons, pros and cons for both, since you're
Many
raising
Indians-
it.
Many Indians do have misconception about the fairy tale success stories in abroad.
Correct.
My lord, anyway, my lord, highly obliged, my lord. Can we just, I got
Yes,
another
yes,
matter.
yes.
Highly obliged.
Please, that's all, minute. The alternative submission, if my lord is not pleased to consider my first
So do you
submission,
want an order on merit on this IA of yours?
I leave it to your lordship.
Or
I have
if you-
made only my submissions. I'm grateful to your lordship.
No, if
because-
you agree that this matter back to the family court, I will say so. If you want an order on merit, I will pass an order on merit, passing how your application whether sustainable or not, or should I grant or not?
Milord, if the matter ultimately is to be sent back to the family court, an order on merits may not be necessary because that would again come in conflict and would confuse the family court.
Correct.
And now that Milord IA can be considered within a week, as you please observe, a consent order may be passed.
Consent,
Consent,
right? No consent.
He said yes.
No, no.
See, what will happen
You
for
filed
your
there, no
benefit
consent.
also,
Why should I consent?
even if you have not filed anything, and if you want to place any material.
Go do that. That's all.
Except this Milord, your lordship was pleased to observe that there is very same IA will be directed to be considered by the family court. The same may kindly be done.
Okay, Markot.
IA number 2.
So this is going to be only orders on IA number 2 and
please,
not on the petition and what is filed.
Well,
by-
petition also can be disposed of on my submissions made. One permanent settlement might be made and disposed of. Why should it be pending is my submission.
What is your submission on
No,
that?
so far as is IA number 1 or the disposal of the writ petition itself is concerned, but I can't say, I can't have any say because it is his discretion. He has come here and he wanted to challenge the order passed by the family court. If he doesn't want to within a week.
Where is that application which you mentioned?
Page 19, my lord. 19, Annexure C.
In the memo, is it?
In the memo itself, I have produced along with the writ also, but in the memo I have produced for convenience sake, my lord. Page 19, Annexure C.
Yes, yes.
That is my prayer.
See, if I have to dispose of the petition as well as IA number 2, his petition for grant of this order of visitation rights, which is
But that can also be considered by the family court only.
No, no, no,
The
no.
changed
No, 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 no,
visitation
no. It
rights.
is, no. That's under challenge.
Honorable court passed visitation rights during the vacation only on the applications filed. So
No,
no
that is-
final order is
no,
passed
no,
on the family court's order. It can
No.
be
No,
writ petition which is filed by him.
Please.
on orders passed on this IA.
Is questioned on IA number 3 filed by him.
Yes, and orders passed then one.
And the orders passed.
No, he
That-
wants to, he has filed an IA here to amend the petition in the family court, which can't be done. Because an amendment petition can be done only in the family
Amendment,
court.
I'm not pressing here, my lord. I'll file. I'm not pressing.
That may be recorded. Amendment if he is not pressing.
Here, that I'll press it before family court. I
See,
mean,
now, what is questioned is the orders, impugned order of the family court, whereby the entire relief sought for in IA number 3 is not granted. It is reduced to only some few hours in the morning or Saturday and Sunday. After that, this court has passed orders, several orders, granting him visitation
During vacation.
during visitation.
Only during vacation.
Visitation, so many other things.
No,
But nothing-
visitation during vacation, my lord.
Correct, sir.
Not other times.
You are agreeable with that, I will pass an order, dispose of the writ petition.
No, my lord, my kindly consent. My lord, if my IA were to be considered or are against, that will have a repercussion on the visitation application filed by the father also. Therefore, that has to be considered first.
Which one?
My lord, the IA number 2 filed here, which my lord is pleased to direct the family court to consider. If that is considered, the entire visitation rates will be, my lord, a different panorama. Therefore, that has to be considered first. If it is dismissed, that's a different thing. If it is accepted, then family court also will have to reconsider the visitation rates of the father.
Fact remains that you have parted with custody visitation rights. This court has granted him visitation and custody rights
No,
during
but
vacations.
during
He cannot wait for the family court or this court to pass an order on IA 2 and thereafter decide when the
My lord,
father
your
has to meet
lordship
the
said
child.
only 1 week. IA 2 will be decided only in 1 week. That can be
I may
considered.
not say 1 week. I may not say 1 week. You have read the latest judgment of the Supreme Court, which says this court, the
They're
high
not
courts
fixed
do not
time.
have powers to fix
Then
time.
my lord, my lord may kindly pass an order of merits on my IA number 2.
very, on both the IAs.
All right.
Goble.
Then what about the main petition?
It is left to him, my lord,
No,
whatever he wants to do.
Want to argue on the main petition?
Not now, my lord. My IA 2 may kindly be considered now. On the main matter, I'm not prepared to make submissions on the, my lord, the merits of the writ petition.
Yes, work Heard. Learned Senior Counsel, Shri. This is serial number 21. Shri
Gangadhar
Bandagi,
for the wife.
Senior Counsel Shri Anant Bandagi for appearing on behalf of Kaveri Timaya for the petitioner. father and learned senior counsel Sri Gurunath Gurumathal.
Gangadhar Gurmat.
Gangadhar Gurmat, senior counsel, on behalf of Parvati R. Naya for the respondent mother. This is a proceedings arising out of a matrimony MC case.
Yes, MC case, filed by the husband petitioner.
Husband and wife, and instead of father and mother, say husband and wife. The present petition is filed by the husband, questioning the impugned orders passed on IA number 3. By the learned judge of family court at Bengaluru, whereby the application seeking custody and visitation rights by the father of the minor child, Master Rayansh R. Hegde, came to be partly allowed, granting him visitation rights on alternate Sunday between 11 AM to 4 PM. And he was permitted to make video calls on alternate day for about 1 hour. Full stop. It is seen that subsequently, after filing of the present writ petition, several orders came to be passed by this court, right from 14/1/2022 till 19/12/2024, for about almost 6 to 7 orders, whereby interim visitation rights and custody rights were granted in favor of the father by this court, permitting the father to visit and have custody either in Bangalore and also to take the child to Mumbai.
Please.
Mumbai. Full stop. Para. During the pendency of this petition, the respondent wife has filed IA number 2 of 2024, seeking the following reliefs. Extract the reliefs, IA number 2, marked in orange. Full stop. You have filed objections to this?
Yes, yes. And we have raised the ground of maintainability also.
The sum and substance of the application IA number 2 filed by the wife is with regard to a direction to be given to the petitioner husband to give consent to give the passport of the minor child, Master Rayansh, to the respondent, and to give consent for renewal of the passport and for obtaining visa to United Kingdom. Want to have some water? Have some water. The petitioner husband has filed detailed objections to this application. Primarily contending that the present application is not maintainable before this court. As it is in blatant violation of the hierarchical jurisdiction of the courts and also the opportunity for the petitioner, in case he doesn't succeed, to challenge the order before this court and subsequent challenge, which is a matter of his right before several courts in hierarchy. Thereby, by directly filing before this court, he would be deprived of a challenge, one challenge that he can make before this court if he's aggrieved by the said such order, if it goes negative against him. Full stop. It is the vehement contention of learned senior counsel for the respondent that the present application is filed as there is a great urgency for the respondent wife to travel to UK for better prospects. And she's in the course of securing a job for herself. And so also for better academical and intellectual growth of the minor child in UK, which would enhance his educational qualifications and prospects in future. It is not in dispute that both the petitioner is also a doctor?
No.
Not in dispute that the respondent is a doctor. Pursuing career in ophthalmology presently, and intends to take it further for higher studies and specialization in ophthalmology in UK. Full stop.
My apologies. She doesn't want to pursue higher studies. She has completed higher studies and she has passed exams in England. That's why she got an offer for employment.
Okay, so not further studies.
No, not further
for
studies.
better job prospects in ophthalmology in UK. As it would enhance her earning capacity and her medical expertise and skills. Full stop. It is also contended by the senior counsel for the respondent that by allowing this application or considering this application, there would not be much of a hardship or inconvenience to the petitioner for the reason that these objections are filed to the said application, and this court has the powers to deal with the matter in its discretion, as child custody rights and visitation rights are only temporary in nature and it is never permanent, and it can be exercised and adjudicated and modified at any stage and before any court. Learned counsel further contends that in view of the urgency involved and the job prospects, it may take little longer time if the same has to be adjudicated before the family court in the pending matter, in the pending proceedings. Therefore, he requests this court to proceed further in the matter to pass an order and allow his application consequently, and the IA number 2 of 2024. Full stop. Per contra, learned senior counsel for the petitioner, as stated earlier, has raised a serious challenge to the maintainability of this application itself by contending that this application is filed for the first time before this court. It was not filed before the family court. This is not in aid to the main petition preferred by the petitioner, who has only questioned the correctness of the orders passed on IA number 3, which is scuttled and not fully granted by the learned family judge, whereby the visitation rights as sought for in IA number 3 is not fully granted in favor of the father. Under the circumstances, he contends that there is no impediment or hindrance for the respondent to have filed this application before the family court. And he has come up with this application only with an intent and motive to see that an order is passed by this court. And he can, if passed in his favor, he would take the minor child and the rights of the father would be deprived for custody and visitation. Therefore, he contends that he has serious objections with regard to every statement and averment made in the affidavit annexed to the application. And he would contest the same before the family court on each of such averments, including the travel of the child to United Kingdom, as he would be deprived of his basic fundamental right of visitation and custody as a father. Full stop. Para. I've heard learned counsel for the, before that, madam, learned counsel for the respondent has relied on the following judgments in support of his case. Learned counsel for the senior counsel for the petitioner has also relied upon the following judgment in support of his case. Full stop. On a careful perusal on hearing these submissions, erudite submissions of a learned senior counsel for the petitioner and learned senior counsel for the respondent, it is seen that the present application is being filed with an intention, with a prayer for a grant of an interim order for a direction to the petitioner to give consent for the passport, for securing a visa and other requirements for travel to UK. Full stop. Apart from the judgments relied with regard to the orders that could be passed by this court on the interim custody and visitations, the learned counsel for the senior counsel for the petitioner has relied upon a judgment of the Honorable Apex Court in the case of Shyam Sale and Power Limited and others versus Shyam Steel Industries Limited, reported in 2023 1 SCC 634, whereby para number 29 of the said judgment would be relevant, which is extracted here. Full stop. Para 29 extract mark part. Full stop. Para. The learned senior counsel representing the respondent has also relied upon the judgment of the Honorable Apex Court in the case of Ritika Sharan versus Sujay Ghosh and other judgments, more specifically para number 18 of the said judgment, which reads as under. Having perused these two judgments, these judgments, and considering the facts and circumstances of the case, what is required to note here is the application that is filed for the first time before this court seeking for certain reliefs to be granted with regard to the consent being given by the father for securing the passport, securing visa and travel and other things as sought in IA number 2. Full stop. In the administrative law jurisdiction, there is a fundamental principle of hierarchy of the courts formulated in our country. Therefore, the hierarchy of courts would have to be followed in the exercise upon the settled principles of law and by following the due process of law. it cannot be said that merely for the reason that there is a delay and protraction or the duration being consumed longer in the trial court or the family court, that the petitioner or the aggrieved party could directly approach the higher court for seeking relief. In the present case on hand, an application is sought to be filed for the first time before this court. And it is to be kept in mind that this court is not dealing in the matter as an appellate court. It is in the writ jurisdiction, considering an application being challenged on the orders passed by the family court under the jurisdiction of Article 227, the Constitution of India. Full stop. Therefore, considering all these aspects, in my humble opinion, it would be proper and appropriate for the respondent wife to file the present application, or this application could be treated as an application before the family court, have been filed before the family court, and then a copy of it could be filed before the family court. Objections already filed, the parties are at liberty to file any further documents and objections, if any, and the matter could be adjudicated before the family court in a time-bound, in an expeditious manner, as this court would not want to take the matter against the hierarchy of the jurisdiction of the courts to entertain the present application, which in the normal course is required to be filed before the trial court, the family court in the present case, or the trial court dealing with the matter. Full stop. Under the circumstances, this court is not inclined to delve into the merits of the matter, as it would hamper the rights of both the parties. Hence, I pass the following order. The application filed under I number 2 of 2024 would not be sustainable before this court. The same shall be placed before the family court in the proceedings pending before it, to be taken up on priority. And the objections, if any, could be filed further by the petitioner, and so also any further documents, if required, could be filed by the respondent here before the family court. Full stop. The family court shall decide the matter expeditiously, considering the fact that there is urgency for the respondent to travel abroad for her future better prospects of her job prospects, and so also for the child on its own merits. Full stop. It is needless to mention that this court has not expressed any opinion on the merits of the matter. Full stop. Parties are at liberty to place all such material before the court and argue the matter before the family court. Full stop. In view of the fact that the matrimonial proceedings itself is of the year 2020, and we are still at the stage of interlocutory applications, this court deems it appropriate to direct the family court to dispose of the matter, dispose of the application IA number 2, which is filed here, within a period of how much time it would take?
Actually, time limit, expeditiously, Your Lordship.
No.
Expeditiously ಅಂದ್ರೆ
No,
ತುಂಬಾ
no,
ಕಷ್ಟ ಆಗುತ್ತೆ.
what the Supreme Court has said in final matters is different from these kind of matters. 1 month I correct. Within 1 month. 15 days.
Family court, so many matters.
Within
I
1 month.
understand 15 days ಅಂದ್ರೆ ಇದಾಗುತ್ತೆ. I leave it to your lordship.
1 month matter. The act itself contemplates
1 month.
the entire petition to be decided in 6 months.
Yeah, 6 months. 1 month.
The application shall be decided and suitable orders be passed within a period of 1 month. When is the next date of hearing?
3rd March.
1 month from the next date of hearing. Full stop. Full stop. One more paragraph add. In view of the provisions of section 21B, clause 1 and 2, contemplated under the Hindu Marriage Act, which itself states that any matrimonial proceedings filed before the court shall be decided within a period of 6 months. The applications invariably would have to be decided within a period of 1 month after giving reasonable opportunity to both parties. In the special facts and circumstances of the case, since there is urgency so shown by the respondent wife, the application shall be decided within 30 days from the next date of hearing stipulated before the family court. All contentions are kept open.
Please.
Within 1 month. Within 1 month.
Please, grateful to your
No,
lordship.
the writ petition will have to be heard, my lord, because now what I argued on IA, that also one date may be fixed and we can finish that.
After 2 weeks for.
Very
No, after that date, my lord.
good.
So that whether this survives or not,
No,
we
no,
can also be
you can't do
decided.
that, my lord, because that has got nothing to do. One date may be fixed, we'll finish this.
After 2 weeks, I'll post it.
Please,
Oh,
ma'am,
very
please, ma'am, please, ma'am.
Very.
Meanwhile, this application maybe the family court will decide even before that also.
Please.
So kindly fix a date after 2 weeks, my lord, we'll order.
All this matter, 2 weeks on date could. Huh? March. No, we were on 14th March. 14th March.
No blame.
Please.
Pleasure.
Yes, sir.
Grateful to your lordship.
Thank you for
Appreciate
assisting both the senior counsels, Mr. Gurmat and Mr. Mandigi. It's a pleasure.
It's a very, very fair order, my lord, that
No,
anybody.
it's a pleasure to hear both of you.
God bless your lordship.
Oblige.
Lordship, I appear for the petitioner in this matter.
Lordship, I appear for respondent.
Lordship, I heard the matter on IA.
Yeah, which is it?
My
22.
If your lordship may
October
recall,
करता है इधर।
if your lordship may recall, you had met the child in chambers, my lords, on
Ah.
the last occasion. And your lordships has observed the child, how he behaves with the father and all.
How is?
How he behaves with his father and all, my lords.
What is the name
We'd
of the
like him
child?
to meet
Aditya.
Aditya.
Ah,
Took great efforts to reconcile and
why it was urgent today?
your lordships have told that there is no amicable settlement between the parties with respect to visitation rights, and the lordship has posted matter for hearing on IA again on this date, my lords. My lords, the IA was to
Ajay Nayak and Shalini Nayak.
my lords, the respective IA is with respect to sending the child for counseling to Nimans. During this pendency of IA, your lordships wanted to meet the child because there were 3 interim reports filed by the doctors
Aditya.
in the trial court, my lords.
Okay, what is the report?
The said reports are
How old is the son?
now he is 6-year-old, my lords.
6 years.
Yes.
So what is the application that is here before this court?
Direction to the
The impugn-
respondent.
Huh?
Take the child to the expert counselor at Nimans at Bangalore and file a report.
Order sheet ಕೊಡಿ.
The IA direct the respondent wife to subject Master Aditya Nayak to an expert counselor at Nimans. Your lordship may recall, this is the child, my lords, who has told that he'll be pursuing law.
Huh?
He'll be pursuing law ಅಂತ ಹೇಳ್ಬಿಟ್ಟು
ಯಾರು?
ಮಗು ಹೇಳ್ತು.
Who's pursuing?
The child told in front of you that he'll pursue law, etc. ಅಂತ.
He wants to pursue law.
If your lordship recall the.
I'm unable to recall. That's why I'm trying to see if I can see the photographs, if any of the child or the father and mother.
Photograph of the child.
Photographs produce madilva?
No, my lords.
May take up the matter, Mother Day. Senior would assist the court.
Who had argued, senior? Who had argued?
Arguments were heard in part, my lords, with respect to the IA. Main matter, it was not heard. In the meantime, you wanted to meet the lordships who wanted to.
Correct. What was the IA? What was the IA direction, is it?
Direction.
IA for direction to directing the respondent to
But counsel.
IA 3 of 24. Subject Master Aditya Nayak to an expert counselor at Nimans.
Is this the boy who had come, was called here in the open court? He came and spoke on the mic? No.
No. In chamber it happened, my lords. Your lordship were pleased to take it in chamber, and the child cried when he didn't meet the father. He was not ready to meet the father. Your lordship also spoke to the child individually with the mother, accompanying mother-in-law.
Then my lordship told the mother at least to make child meet grandparents. Lordship recall.
This is what happens to many child custody cases. All right. There is the photograph.
There are two reports, my lords, that are against the father.
Yenanta?
That the child should be given more time to adjust, and he should.
Now you are appearing for the
Petitioner in
Father.
this case.
father. So some visitation rights are given to you. You are meeting the child.
Now it's not
Happening.
The visitation which was given has been stayed, my lords. That is IA 10. IA 10.
That is the impugned order.
That is the impugned order.
So order is on IA number 4, is it?
Orders are IA number 10, 99, page number 99 of the writ petition.
IA 10. Okay. Restore the visitation rights.
IA was filed to set aside the order dated 7/7/2024 and permit the respondent to continue visitation rights. And one Ravish Tunga doctor was appointed, and this is the second time the doctor is
I'll
getting
list this
appointed.
after 2 weeks, we'll see.
Please. My
So
lords,
now whether any report is filed by the NIMHANS after the child was referred?
child was not referred to
Not
Nimans. The
referred.
IA is still pending, my lords. My lords, in the meanwhile, the father has told that there is no end point to meet between the parents, and they are ready to separate. And lordship have told that keeping the visitation rights aside, the both are ready to
Sort out.
sort out.
Are you ready?
I am willing to separate part. I am the one who has filed for divorce, and they have filed counterclaim, restitution of conjugal rights.
So
in
what
the
is the
same-
employment of your client? What is she working?
She is working, my lord. She is an engineer.
What
She's-
about him?
He is also engineer.
Then why don't you sort out and file for mutual consent and then agitate your custody rights?
If your lordship may make some order on this in this here, it will be easy for our respective parties to agitate in the family court. my
No,
lords.
that is for you to, I cannot make an order. That is not in, I'm not sitting in appellate stage. So you both have to agree. If you don't agree, then you have to go fight it out on the merits of the matter.
Much obliged.
So if there is no meeting point, you might as well part ways and agitate, keep the,
In
is
fact,
there a custody petition pending?
no, my lords.
You
Only
can-
the application for visitation is pending before the trial court. Before this
Custody
court.
rights, the petition can be filed by either of the parties, by the father actually. Now the child is with the
Child is
mother.
with the mother.
How old is he?
The father actually files a GNWC case. But lack of jurisdiction, the court
How old is
dismisses.
the child?
Child is 6-year-old, my lords.
All right, call this matter after 2 weeks to request. Date maybe. Come up because the roster may change basically.
Much obliged.
Sarita Kulkarni. He is a government advocate. Pass over. Huh? Ilva. Vijay Kumar is not there today. All right, at a request of a respondent, all this matter next week.
My lord, senior is on her legs in another court. She's held up. It may be taken up at 2:30.
Afternoon. You were not here when it was called. No, that's okay. We'll see in the afternoon.
Please.
And 2:30. So this is the only Passover matter. 41. Take up in the afternoon. Yes, 2:30.
See. Serial number 130, I am not feeling well. Serial number 1160, 116, I am not feeling well, my lord, that's why.
ಕೋರ್ಟ್ಗೆ ಹೋಗಿದ್ಯಲ್ಲಮ್ಮ.
ಇಲ್ಲ ಅಲ್ಲಿ ಕೇಳಿದೆ, ಅಲ್ಲಿ ಇಲ್ಲಿ ಅಂತಾರೆ, ಅಲ್ಲಿ ಬೆಳಗ್ಗೆಯಿಂದ ಹಿಂಗೆ ಓಡಾಡ್ತಾನೆ ಇರ್ತಾರೆ.
ಎಲ್ಲೋ ಕೇಳಿದ್ರಿ ನೀವು?
29.
Huh?
116.
ಎಲ್ಲಿ ತನಕ? Okay. What do you want here?
Date, my lord, next hearing date.
You are for whom? You are for whom? Petition. Counsel for petitioner seeks time. Call next week.
4th and 4th.
Not at your choice. You argue today or next week. Yes. What do you want? Counsel for appellant seeks time. Call next week. Huh. Appeal is admitted, stay granted. Counsel for R2 seeks time, call after 2 weeks.
Lordship, serial number 45. The other side is present, your lordship, the 1 week's time, your lordship.
Yaru Maheshwarappa Prasad.
Prasad and Ramakrishna insurance line. 1 week.
At request of counsel for the appellant, call this matter next week. Yaudu? 76 ಅಲ್ಲಿ withdrawal ಅಂತ ಕಳಿದಾರಲ್ಲ. Any objection for withdrawal? Registry to secure trial court records. ಇರುತ್ತಲ್ರಿ ಅದು. Counsel for the insurance company seeks time. Call next week.
Serial number 56, my lord. I am for the Ravi Samprati. ಅವ್ರು ಇರಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು ಮಧ್ಯಾಹ್ನ. Wait time maybe.
You are for?
Ravi Samprati. ಅವ್ರು ಇರಲ್ಲ ಮಧ್ಯಾಹ್ನ ಅಂತ ಹೇಳಿದ್ರು my lord. ಟೈಮ್ ಫ್ರೈ ಮಾಡಕ್ ಹೇಳಿದ್ರು. Serial number 50.
Request of R2, call this matter next week.
Madam Court Officer? Madam Court Officer? Serial number 77 ಇದೆಯಾ?
ಒಂದ್ ನಿಮಿಷ ಚೆಕ್ ಮಾಡ್ಬೇಕು.
ಮಾಡಿ.
77 ಇದೆ ಮೇಡಮ್.
Okay, thank you.
ಹೌದು 2 weeks to comply. ಅದೇನೋ ಕಂಪ್ಲೈನ್ಸ್ ಇದೆಯಲ್ಲ ಅಫಿಡವಿಟ್ ಅದು ಇದು. ಶ್ರೀಧರ್ಗೆ ಹೌದು 2 weeks. 7 ಲಿಸ್ಟ್ ಅಲಾಂಗ್ ವಿತ್ ಏನೋ ನಂಬರ್ ಕೊಟ್ರು. ಬೆಳಗ್ಗೆನೆ ಮೂವ್ ಮಾಡಿದ್ರು. ಹಾ
Serial number 11, my lord. Mail for the appellant, file memo for dispensation to respond number 2.
Notice to R2 dispensed.
Respondent number 1 and 2, serial number 40.
40. 40 na? Serial number 40. Notice to R1 and 2 dispensed. Issue notice to R3.
Serial number 36. R1 notice may be dispensed.
R1 dispensed.
R kindly issue notice to the R2
R2.
and the serial number 38 also.
R1.
R1 notice may be dispensed.
Notice to R1 dispensed. Notice to other respondents.
45 and 47.
Yes.
To R1, both the cases.
R1. na?
R1.
Notice to R1 dispensed. 47 also?
47 also.
Issue notice to other respondents.
Serial number 29, my lord. R1 may be dispensed.
Notice to R1. Issue notice to other respondents. All other matters, notice to respondents.
Serial number 27, my lord.
Yes.
R1 notice may kindly be dispensed with. I will file a memo to the registry, my lord.
Notice to R1 dispensed.
27.
Issue notice to other respondents at request.
Amendment application.
Suppose I email not run.
Three petitions have been clubbed.
Huh?
3 petitions have been clubbed together.
Hmm.
Husband has filed a petition for divorce.
Illi 3 iradu eradu illi.
Alla, ಇನ್ನೊಂದು GNWC that is not connected to this state petition. But all the matters have been clubbed. Family.
So one is MC, GNWC, and what? And then?
And then the petition for divorce has been filed by the husband. And petition for restitution of conjugal rights has been filed by the wife. Your lordship may kindly peruse. Now at the objections have been filed, parties have led evidence. And at the time of arguments, in order to clarify certain vital facts as well as the law, the petitioner has thought fit to file an amendment application. That amendment application has been rejected. The amendment is at page 123.
ನೀವು ಕಂಪ್ಲೀಟ್ ಮಾಡಿದ್ರಾ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್?
ಇಲ್ಲ, ನಾನು ಮಾಡೇ ಇಲ್ಲ.
ಸ್ಟಾರ್ಟ್ ಮಾಡಿರ್ಲಿಲ್ವಾ?
ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ವಿ, ಅದರ ಟೈಮ್ ರೀಚ್ ಆಗಿಲ್ಲ ಅದು. ಸೊ ಇಟ್ ವಾಸ್.
This is seeking amendment of the pleadings.
Okay. Yes. Before adverting to this amendment application, my respectful submission is that lordship may kindly peruse section 23 of Hindu Marriage Act.
Where is your application for amendment?
That is at 123, page 123. I am referring to WP 713 of 2025. That is an amendment application filed in the divorce proceeding filed by the husband.
amendment is sought in all or only in the divorce petition?
In both the petitions, amendment is sought on the same lines. Decree.
So you are appearing for the wife.
Wife.
So respondent therein filed application for amendment
Amendment
of statement of objections in the first matter.
in the first matter. The amendment is to the effect that the factual background to the filing of the said application arose.
All right, that I have understood.
Yes.
Now, what is it that law you want?
Section 23, your lordship may kindly see.
Ah.
In any proceeding under this act, whether defended or not, if the court is satisfied that any of the grounds for granting relief exists, and the petitioner, except in cases where the relief is sought by him on the grounds specified in subclause A, B, C, and 2 of section 5, is not in any way taking advantage of his or her wrong or disability for the purpose of such relief, and where the ground of petition is the ground specified clause A, subsection 1 of 13, the petitioner has not in any manner been necessary or connived at or condone the acts complained of, where the ground of the petition is cruelty, petitioner has not in any manner condoned the cruelty, and when a divorce is sought on the ground of milk, that is different. So therefore, he cannot be permitted to take advantage of his own wrong. That is my first submission. Fraud has been played. That is the second submission. So he cannot take advantage of his own wrong. This concept of law is invoked in my amendment application. For that reason, now your lordship may kindly peruse as I said earlier, he himself has stated in the petition by giving the address.
Same address.
Same address, and in the petition also, he has not taken or averred any fact, because when it comes to living together or under the same roof and when a petition for divorce is filed, now it casts an obligation on the husband to aver a fact that whether he had cohabited with the wife or when the last cohabitation was there. It is mandatory. Otherwise, the presumption of cohabitation arises. Now, in this case, what has happened is 28th February 2015 was the petition filed. 15th of March, the notice was served to the petitioner hearing. Until that time, they were together.
15th March. 15th March.
15th of March.
Even after filing?
Even after filing.
1 month.
Almost 1 month. Therefore, now he has admitted that we are living together in the petition himself itself in paragraph number 20, page 21. It is submitted that the petitioner and the respondent are still staying together in the same home, but the respondent is not showing any care, love, and affection towards the petitioner as beautiful wife. On the other hand, the petitioner was patiently waited and borne all mental trauma and torture given by the respondent, but now the mental torture for him reached to an extent that it is impossible for him to stay with her. Therefore, now subsequently also in the cross-examination which I have produced, he has stated, yes, I was living together, and when a question was posed to him that what prevented you from taking an averment, that when was the last cohabitation, he says that I had no impediment, but I did not plead it. And I also asked a specific question in the cross-examination, when was the last cohabitation? He refuses to answer. Therefore, kindly see the concomitant effect of all these things, the entire gamut of the case, where the petitioner, by his own wrong, he wants to take advantage of his wrong. And it is as per section 23 also, and in the civil pleadings also, the civil law is concerned. The petitioner or the plaintiff cannot take advantage of the respondent, weakness of the case of the respondent. He has to stand or fall on his own pleadings. Now, pleading forms the basis of the case. Now, at first, he does not plead, and in the evidence, he does not give a specific answer. Now, Your Honor, your Lordship may kindly see that becomes a predicament for me, even though a presumption is there. Presumption is there, but still I have to aver and I have to plead all these facts. Otherwise, the other side may take a contention that that is not your case. Presumptions may be rebutted. I cannot presume certain facts, that those contentions they may take. So in order to ward off all those things, and nothing is incorporated fresh. No new additional new facts have been taken by the petitioner by way of amendment. It's only a question of law, and as per his own say, we have incorporated that he was cohabiting continuously. Therefore, he cannot, the question of law comes into play, that he cannot take advantage of his own wrong. Therefore, he has condoned. Second aspect is fraud has been played because he has not, even in the cross-examination, he has stated, yes, I did not inform the wife regarding the filing of the case. He could have stated, he could have informed me after filing the divorce petition against me because we were living together. That he did not do it. Categorically, he has submitted. That I have produced. That is at page 118. His evidence has been para 10, page 118. Reflecting a question is one thing, denying a question is one thing, and specifically stating in positive manner is another thing. Yes. Now, your Lordship may kindly peruse this particular aspect. ನಿಮ್ಮ ಮತ್ತು ಎದುರುದಾರ ನಡುವೆ ಪ್ಯಾರಾ 10 ಪೇಜ್ 118.
Yes, ನಿಮ್ಮ ಮತ್ತು
ಎದುರುದಾರರ ನಡುವೆ ಯಾವಾಗ ಕೊನೆಯ ಬಾರಿಗೆ ದೈಹಿಕ ಸಂಪರ್ಕವಾಯಿತು ಎಂದರೆ ಸಾಕ್ಷಿಯು ನನಗೆ ನೆನಪಿಲ್ಲ ಎಂದು ಹೇಳುತ್ತಾರೆ. Can he say like that? Because he filed the petition on 28th of February and kept quiet, and even he admits that I did not even send a notice, I did not send even telephonic message, even I did not tell her openly that I have already filed a petition for divorce. It is not fair on my part to live with you. All these things he has not done it. Therefore, it is a right accrued to the other party. I have to state the true facts because it goes to the root of the case, the conduct of the party. Therefore, I thought fit to elaborate these things by stating that I have stated so. I have stated so that we were living together, we were fine in the statement of objections. Your Honor, your Lordship may kindly peruse the statement of objections where this particular elaboration was required in the para 34 of the
reduce the fan, or if it is one, then switch it off.
Para 34, that is at page 62 of the typed copy of the objection statement I have filed. Page 62
of the petition.
Of the statement of objections filed to the divorce petition.
Statement of objections?
I am the respondent to his petition. So I sought amendment to the statement of objections. Page 62.
62.
Typed copy. It is the typed copy. Para 10, para 34.
It's already marked. You have read this earlier also.
Pardon?
You have read it earlier also, I think.
No, this paragraph with reference to his evidence, I did not. And with reference to the statement, the amendment application, the respondent most respectfully submits that the petitioner at the instigation of his parents and sister, he has filed the above suit when the petitioner and respondent were living together in the matrimonial home and they were harassing the respondent like anything, for treating her, etc., slave, etc., etc. So in this paragraph, I have stated that I was living together, but thinking that the matter may be settled, your lordship may kindly peruse the any intention or expectation of a wife that even after filing of the petition also some good sense may prevail over the husband, so settlement may occur. All these things runs into the mind of the wife. Therefore, this particular aspect of cohabitation, most probably she might have felt that this cohabitation aspect and all these things could not, if stated so, it would have put her in an awkward position. So therefore, this was not specifically stated that they were cohabiting together all those days after the filing of the petition till the notice was received. Now, your lordship may kindly peruse this 123, page 123. This is the only amendment where new facts have not been pleaded at all. I admit that if a new fact has been pleaded, due diligence would have come in my way of dealing with the certain facts and circumstances where I had the knowledge and etc. But this is not so. It is submitted at the page 123.
This is IA number 30, is it?
IA number 30. Now, the other side has been taking a contention that it is after 10 years and many number of advocates have been changed. Yes, I admit there is no denying the fact that it has long been 10 years. But in all these 10 years, the husband was also pursuing mediation. Not once, many times. Even I came on record also, the husband expressed his willingness to settle the matter. Therefore, in all these 10 years also, many number of panchayats have taken place. That has come in evidence. Even they have also suggested many number of settlements, panchayats. And in all the panchayats, in fact, even after filing of the petition also, the petitioner had attended the birthday celebrations of the son. Each year, and every 3 months he used to come to the house. It is not the case that he had cut off all his relations or communication with the wife and the child. It is not so. Therefore, all these years, panchayats over there, mediation was being taken. It was delayed. I admit it was delayed because of all these things. Your lordship were to see the order sheet. It is for settlement. It is for mediation. It runs like that. Now, when the husband stated categorically that he was not in favor of any settlement because of various, even when I asked him in cross-examination also some set, because they are fighting this litigation either this way or that way, you can settle the matter. He said that, no, I am not in favor of any settlement. That's all. And yesterday also I asked my client and she also stated, with respect, I submit no harm or no intentions or like that. We have produced a photograph where it is a fact, even though it has not been stated or taken a contention before the court, that he has married. We have filed a photograph. No, we have filed a photograph. That's what I said. No, he has gone with trips. My client has stated, be that as it may. If he is ready, I am willing to live with him. A photograph is confronted to him along with a child. He has gone to trips and he purposefully has stated he does not know who the person, the lady was in the photograph. He goes to a trip, goes to pilgrimages, and he does not say that I do not know her. It is seen, it has been marked in the evidence. All said and done. That's what I have been stating before this honorable court. That even otherwise also, that my party is ready to go and settle with him. by withdrawing all the cases. There is no serious dispute between the husband and wife. Even the husband also stated that there was no serious disputes.
So
All the
now you are trying to say that you want to join after he has got married to somebody else.
That's what. Only for the sake of the child, to get the father's love and affection, I am ready. I make it a very.
That anyway, he may be meeting the child.
No, he is not meeting the child.
How old is the child?
Child is more than 14 years.
He is no more a child, he is a teen.
The teen.
He's in his teens, so he may be coming and meeting.
Wants the father's love and affection. That's what my client has stated.
That we'll see whether he's getting the love and affection or not. Next.
Therefore, now this amendment application is like this. It is submitted that the petitioner and the respondent were cordial and they were happily living in quarters situated at Hepal, which is admitted fact. It is submitted that the petitioner was having regular physical relationship with the respondent, but it is submitted that the petitioner with a mala fide intention filed the above petition, alleging false facts against the respondent. It is submitted that the petitioner filed the above petition for divorce on 28/2/2015, and at that time the petitioner and the respondent were living under the same roof and were constantly having physical relationship till the father of the respondent received the notice from this honorable court, sent to the second address, not to the address where, as stated in the cause title of the petition. It is submitted that the respondent did not receive the notice from this honorable court to the address as mentioned by the petitioner, etc., etc. It is submitted that only after the information given by the father of the respondent, it came to the knowledge of the respondent about the filing of the above petition. It is submitted that the petitioner did not inform the respondent about filing of the above petition, nor retracted from physical relationship either before filing of the petition or till the discovery of the above filing of the petition. Therefore, it is submitted as the petitioner had constant physical relationship with the respondent from the date of filing of the above petition till the receipt of the notice by the father of the respondent. From this honorable court, the above petition is liable to be dismissed. For it is submitted that without admitting the contentions of the petitioner regarding the alleged cruelty by the respondent, but for the sake of arguments, it is submitted that the above petition is liable to be dismissed on the count of condonation of the alleged cruelty under Section 23 of Hindu Marriage Act. Therefore, it is submitted that the petitioner cannot be permitted to take advantage of his own wrong. Further, the above petition is also to be dismissed as the petitioner has approached this honorable court with unclean hands and by playing fraud on the respondent as well as on this honorable court. As fraud vitiates everything, the petitioner is not entitled for any of the reliefs as sought. That's all the amendment runs. And it is ex facie, prima facie clear that he did not inform. He also admitted by way of pleadings. He also admitted by way of his cross-examination. And therefore, my respectful submission is that it will not cause any harm to the other side. If the amendment is allowed, no harm is caused, as stated by the Honorable Supreme Court under.
What was the stage of this application?
At the stage of arguments. And with respect, I submit. And even after when this petition was filed, after the rejection of our application for amendment, we approached the court and filed a memo stating that a writ petition has been filed. And the trial court stated that no adjournment application is filed. Therefore, your argument is taken as nil and it has been posted for judgment. With respect, I submit without any other intention that the other side had argued the matter for one whole month. It is on the order sheet. May I take your lordship to the order sheet? To the entire whole month for 5 days, they continuously argued. It's not that they argued for 5 days or 6 days or 2 days. No opportunity was granted to me even for arguments also. It was straight away it was posted for judgment. Now, what I mean to say before this honorable court is that the court is also swayed by the aspect that the wife is doing all these things purposefully. That is not true. That is not true. Now, the lordship may kindly turn to the order sheet where
Yes. The order sheet.
They have produced it by way of objections, entire order sheet.
In which case?
That is at 7/8/2024, page 74. 74, page 74, 7/8/2024, heard arguments of learned advocate for petitioner in part. Further arguments of petitioner by 9/8. Then,
ಎಲ್ಲಿದೆ?
ಅಲ್ಲ ಇವರು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದ್ದಾರೆ 7/13.
There is no such thing here.
ಅಲ್ಲ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಸ್ ಬ್ಯಾನ್.
We have mixed the CP. Statement of objections, page number?
Page number 74.
Seventy-four.
74. Now, after the clubbing applications were allowed, a matter was posted for arguments on May 7/8/2024, heard the arguments of learned advocate for the petitioner in part. Further arguments of petitioner by 9/8. Both counsels present, kept by case called at 3:45 p.m. Petitioner and both counsels present heard the arguments of learned advocate for petitioner in further. For want of court's time, till 5:45 it was argued. Further arguments of the petitioner deferred to 9/8, etc. There 9/8. Counsel for petitioner present and trace time. Further arguments of the petitioner by 28. All along with etc. Then on 28, petitioner and both counsel present, respondent absent, heard the further arguments of learned advocate for petitioner in part and praise time for further arguments. For further arguments of petitioner, etc. 27, advocate for petitioner present, case called, petitioner and except present, heard further arguments of learned advocate for petitioner in full. Advocate for respondent praise time for arguments. For arguments, etc., etc. on the next date, that is on 29/8/2024. Advocate for petitioner present, case again called at 12:30 p.m. Advocate for petitioner present, kept by case called at 2:50 p.m. Petitioner present, then 3:30, then no, because we a wrong date was taken by my colleague. Therefore, we could not be present on that day. It was a mistake on the part. June, no joint memo filed regarding visitation. Respondent is directed to file. Now, your lordship may kindly peruse on the same day. Respondent is directed to file the written arguments on main matter and call along with etc. And further, no opportunity was granted. Next, advocate for respondent present and trace time, because it was the court reminded that you should file written arguments. For written arguments of respondent on main matter, finally 17/9. Call along with etc. Then again it was called on 17/9. Advocate for petitioner praise time to file objection. That is on that day, this IA number 30 was filed. At the time of, even we were not given fair opportunity to argue the matter at all. Kindly see, the order sheet speaks that on that day, one day, my colleague did a mistake by taking another date, and in one single day, we were directed to file written argument. Greater, with respect, I submit, greater latitude was given to the other side to argue and put forth their contentions in number of occasions.
No, on 27/8, you did not argue.
No, we were not present on that day.
Yeah.
29/8.
27/8, you did not argue.
No, we prayed time.
That's why the prayed time means you did not argue.
He did not argue.
29/8, you were not present, you did not argue. It was called out 4 times. On 2/9, though the court has given you time to file written arguments, you did not argue, neither you filed written arguments.
No, the court said that even we were ready to argue the matter. The court said that it is for written arguments.
Where is it forthcoming?
No, it is not forthcoming, but we said, I was ready on that day. The court said that it is for the written arguments.
All right. And after that, you.
And after that, this application came to be filed by way of elaboration.
So even on that day, on 2/9, another date was given for you to
No, no,
file
no.
the written argument.
No, no, after this 29/8, 2/9 was the date.
On 2/9 also, one more date was given to you to file written arguments. On 17/9. So you have not used all these opportunities and you say you have not been given opportunity.
No, no, your lordship may kindly see. The specific case was that the specific contention of the learned judge is that you should file written arguments. I have given the date as written arguments.
That's because 2 dates you did not argue verbally.
No, no, only on one day, because it was.
27/8, you were not present, though you were present, you took time.
Yes, 27/8, I sought for time. And immediately on 27/8, on 29/8, it was posted for written argument in the next day.
On 29/8, you did not argue.
Yes, I did not argue because I was
ಎರಡು
not.
ದಿನ ಆಯ್ತಲ್ಲ, 2 ದಿನ ಆಯ್ತಲ್ಲ.
Allah, the wrong date was taken.
That is your version. That is your version. You don't know why you took the wrong date.
No, no, I did not take because I was not present.
Correct. That's your mistake, sir. When you know the matters of 2015, the petitioner has taken so many dates. You ought to have been ready anyway. You can't say now that you are not given opportunity. All right, even oral, it was not given. 2 dates were given for you to file written arguments. That also is not filed. Then you come up with IA number 30 for amendment.
My respectful submission is that since it goes to the root of the case where fraud is being contended and ex facie, prima facie, it is borne out of the records that the petitioner is guilty of not disclosing the fact of filing of the petition to the wife.
All right.
Therefore, under
So now the cross-examination, examination, everything is over. It is only for arguments.
it is for argument.
That's all. Anything further?
Now,
Let him complete.
this citation. Supreme Court had the occasion to even go through this provision of Order 6, Rule 17, and at any stage this amendment application can be filed. That's what, and under those circumstances, the Honorable Supreme Court has laid down the parameters. And my respectful submission is that the Lordship may kindly turn to para 11(2) of the said judgment. Over the years,
Para 11.
para 11(2).
11(2). Yes.
Over the years, through numerous judicial precedents, certain factors have been outlined for the application of Order 6, Rule 17. Recently, this court in Life Insurance Corporation of India versus Sanjeev Builders Private Limited and other, after considering numerous precedents in regard to the amendment of pleadings, culled out certain principles that all amendments are to be allowed, which are necessary for determining the real question in controversy, provided it does not cause injustice or prejudice to the other side. Here also, no injustice or prejudice will be caused to the other side because it is an admitted fact. This is mandatory as is apparent from the use of the word shall in the later part of Order 6, 17 CPC. In the following scenario, such application should be ordinarily allowed if the amendment is for effective and proper adjudication of the controversy between the parties to avoid multiplicity of proceedings, provided it does not result in injustice to the other side. My respectful submission is that here also, no injustice will be caused to the other side because it is his own act which has resulted in the filing of the petition and as well as subsequent cohabitation, which he has hid from the pleadings. By the amendments, while generally should be allowed, the same should be disallowed if by the amendment, the party seeking amendment does not seek to withdraw any clear admission made by the party, which confers a right on the other side. The amendment does not raise a time-barred claim, resulting in divesting of the other side of the valuable right, accrued right. The amendment completely changes the nature of the suit. The prayer for amendment is mala fide. By the amendment, the other side in mind are, the court should avoid a hyper-technical approach. Ordinarily be liberal, especially when the opposite party can be compensated by cost. Amendment may be justifiably allowed where it is intended to rectify the absence of material particulars in the plaint or introduce an additional or new approach. That's what we are speaking, and we are making a point more clearer and more clarificatory. The amendment should not change the cause of action so as to set up an entirely new case foreign to the case set up in the plaint. That is not our. The question that we have to consider in the above backdrop is whether the High Court fell in error in allowing the application seeking leave to amend pleadings in contravention of the statutory language. By way of amendment, what is sought to be done is the question of validity of the will, on the basis of which the defendant sought to have been sued dismissed. Therefore, the Honorable Supreme Court, by stating it has allowed the amendment application. Therefore, my respectful submission is that no harm is caused, and what are all the by way of amendment which the petitioner wants to incorporate, it is all on record by way of evidence and by way of pleadings, because Order 6 Rule 2 of CPC says that except without pleading, I cannot lead any defense. Kindly read Order 6 Rule 2, where CPC is also applicable to the family courts. We have to plead and we have to prove. That is the cardinal principles of law.
All right.
And therefore, my respectful submission is that since no hardship causes to the other side, we have sought for this amendment of the pleadings.
Yes.
The petitioner lost the child. This is my time. Lost the child to who? And lead to the temple and inform me that he is going to be honest. But the petitioner did not come back immediately. When I called his mobile was unreachable, was not reachable. Upon inquiring with the police, I came to know that he was not called the office also. Immediately she tried to contact the parents in the village, and they were also not picking up the call. And hence I informed my parents. And my father sent relatives to the native to inquire into the petitioner, then came to know that they were all happily in the village. So that means from 20 years he was happily in the village. It is important to know here that the petitioner used to go to the village and stay with his parents for a day or two. And I was not suspecting him while he has done this. And those who will not come back.
And thought, not though, thought.
That he will come back to me. I submit that when such being the matter, I was not knowing that everything was pre-planned by the petitioner to trap me and my parents. That on 22nd February, the petitioner's father lodged a missing complaint of the petitioner against me in Karnataka police station, alleging that I wanted to kill the petitioner to get his government job, and made Galata with the petitioner, and hence the petitioner went away from the house. On 23/2/2015, the police called me and my parents, and we went to the police and gave us statements. The husband of the petitioner's younger sister, was working at the and he was going to investigate the lot of problems. Then next day, the 24/2, the petitioner came to the police station and reported there that he went to Karnataka. Then myself and my father were also called before the police. Then the petitioner and his parents and his brother, sister, all me and my parents, and my The petitioner stated that he needed 1 month time to join me. I have also requested him to join with me in the quarter period agreement, but he was not hearing my words. Then in the evening, my parents went back to their home, leaving me and my grandmother with the child at the quarter. Then the petitioner came to the quarters around 9 p.m. and without talking anything, he went from there taking some clothes. 20 February evening at 6 p.m. he came to the quarters, saw the child and that we were not feeling well, but without bothering, went back, came back at 12 o'clock, entered into the room and locked. And on 27th morning, he left home taking all his belongings. And all those days, I was begging the petitioner to leave this her and this happened. He was not ready to hear my words, and he was not doing all that. I was doing all that. On 27th, 2015, I called the petitioner and informed that myself and the child both are not doing well, and asked him to come back to the house. But he told me he will not come back. And not come back and ask me to go to my parents' house and he will come back and stay there on 28th June 2015. Accordingly, on 28th June 2015 morning, I went to my parents' house. And even after a repeated call, the petitioner never came back. Then she and the child went to the quarters the next day, and from 29th to 2015. At that time, the petitioner and the sister and husband were all present, and after seeing me, they closed the door and had not opened them when she knocked again. The petitioner came out and told her if she wants to come home, he will not stay there, and told her to go back. Then again, I, along with the child, went to the quarter to the petitioner had taken the law and never allowed it to the I submit that having no alternative, I came back to my house, and on 16/3, I was shocked to receive the submission report. Going to the paper, I came to know that on 28th only, he had filed the petition. So the question of cohabitation from the date of filing till they got the summons is derived by her own statement. Then the petitioner, thinking that I would lodge a complaint, had left the house. Thereafter, she has alleged harassment.
No, by seeing the petition.
Yes. Yes. Which?
The first page, 100. Page 100. The very first thing.
You can read 65. Yeah, I thought you are better than me in Kannada. Yes.
No, para 65.
65 ಇಂದ ಓದ್ರಿ 65.
The exemplification executed by the very the entire arguments were over and the case was posted for judgment on 19/11/2021. Then it was reopened. The case has been reopened on 5 occasions. 5 counsels, each one with ingenuity comes with another application. After filing this application.
Where is that first order sheet where the case was posted for judgment?
The only reason why my client was doing Visitation was that was the time he could meet his son. No representation. Again, everything was said,
16.
Case called again, no representation, case posted for judgment on this without asking, written answer.
Subsequently for mediation.
And again, just take lordship's valuable time, because today you are through various orders, respondent has them, counsel has them, it's time. The respondent wanted to engage the service with another counsel, which is unending, that is why I produced the entire audit sheet. Thereafter, you have to define this IA number 13. You have to kindly state how many days will take to argue that IA. That is page 77 on. 28, they find IA. 26, 9, 20, 24. Both parties are present. Both counsels present. That's why case called as a person, fight and objection, for argument, and also for argument of respondent on name. By learned president of flow, he was given a chance to argue on name again on 26, 9, 2024. For arguments on IA number 30 and also for arguments of respondent on name. Matter finally as last done on 22, 10, 2024. Call about the closure. Petition next day, 22, 10. Petitioner and present. Advocate for respondent present and place for time. Advocate for respondent present and file adjournment application. Their own application received for adjournment. Thereafter, file adjournment 2024. Petitioner and counsel present. Respondent and counsel absent. Respondent, and this is telecom matter very easy. Goes on like this, then order is pronounced. The court has rightly held, this is nothing but I may further say, then says that the client wants to rejoin and be there despite dowry has been domestic violence case, all this is the idea of rejoining. Very strange. What I feel a little sad is that the woman who is a doctor after 10 years can't see the writing on the wall. Now I understand that my client alleges that my client is remarried. It is sad that such an application bringing in all sorts of details of their private, so-called private relationship, which never happened because even according to her, after 28, 27 weeks, they were not together. 27 too. It is very sad, I would say. So if such a qualified woman has to be, they not be. I think it should somewhere the courts also state that construction and put an end to and she has said there is a typographical error, and the fifth counsel suddenly came out of the typographical. She has gone on affidavit, and you can see the present knowledge sheet till 4/1/2025. She has still not filed her affidavit.
Still not filed?
And I'd like to place a lordship before you ask the judgment to appeal for.
Thank you. When the matter, madam, according to you, was posted for judgment for the first time on 16/11/2021. Correct? Subsequently, the evidence was listened by both the parties. Subsequent to that, matter was referred to mediation and further cross-examinations also happened subsequent to that.
The rotation 2 years after the
After the matter was posted for judgment on 16/11/2021. No, I thought that your argument was.
Yes.
Page 93 was the order sheet.
93.
Starting from 19.
19. Yes, I'm seeing that.
On 30/4/2015, respondents obtained to Litigation Council. Their appeal was 29/10. Respondent please sign. Then 4/12/2015. Respondent filed first to the IAS. Then the series of dates go, you know, 28/1/2017, respondent absent, cost involved. First page. Next page, 4/12/2017. So as to advocate, there is a first of the advocate. Page 10. Next day, again page 10, 14/9/2017, no representation for respondent. 10/10/2015, again sent out for respondent evidence. 8/11/2017, evidence of respondent finally by 8/12/2017. 8/12/2017, respondent other place of time. Then 8/1/2017, respondent county place of time. So much so that the court was co-exonerated, a commissioner was appointed to take evidence of another party. Thereafter, on 19/2, respondent county place of time. 15/3/2018, respondent place of time. Again, also imposed on 12/4/2018, county was respondent granted time of payment of law. After paying part, 18/4/2018, respondent county place of time. 26/8/2018, respondent county place of time. Next day, 21/7/2018. Finally,
18/9/2018.
thereafter, page 40 over the other time. From 19/7/2021, respondent action. No representation for respondent. Immediately an IAS file, IA number 13/14, and that goes on for a while. Then the fourth wire comes, and then the bill.
What was this settlement talks going to join or to separate?
To join also.
He used that opportunity, but cannot because he get an opportunity to meet the son. And one person wanted to was allowed to attend. That was the last of their meeting.
All right. Yes, yes. Yes, madam. Yes. Page 306, 306. Para? Hmm. 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 Now, 5 years back, I don't know what I have written. Amendment. This also deals with amendment. So what is the final? What is the finally, what is arrived at? Yes. Yes. Hmm. Yes. Yes.
Where there is this long period of continuous separation, a fairly concluded, when a man only gone beyond the fair, the marriage becomes a fiction, though supported by a legal fact. By refusing to sever the tie, the law in such cases does not serve the sanctity of marriage. On the contrary, it shows scant regard for the feeling and emotion of the parties. In such situations, it may lead to mental cruelty. And they are dealt with that. And this particular case, I think, of the respondent to it is nothing less than because she is feeling hit all of the allegations. Apart from that, prolonging this litigation effectively is was the last of the judgment 2020 SC 197.
Page? Internal page 6, paragraph. You're reading where, madam? Of which judgment? Rupa Soni's case. Para 14. In Samar Ghosh, okay. All right. In Vishwanath Agarwal, Sarla. No, it is not underlined here, so I would not know. So you are reading para 32 Samar Ghosh. Yes, yes.
Similar human ingenuity has no bound. Therefore, to assimilate the entire human behavior in one definition is almost impossible. What is cruelty to one case may not amount to cruelty in another. Cost of cruelty differs from person to person, depending on the level of education, family, and cultural background. Therefore, apart from this, the concept of it cannot be interact without being that kind of order. I will just like to say, nothing of and then after the last
Yes.
we are very limited to say on tax, especially upon very responsible with the bar. They do speak for themselves. The marriage was organized in 2012, parents were not set up, disputes between the parties started after 2006 onwards. They current wife, which something and the day and 3 and 4 of the dowry. Husband has been paid paragraph 20 related in our party. Therefore, both two that there will be no point in the overtaxed pedantic in the
Yes. By
all the educated and what is her ultimate motive is nothing but vicious prostitution. For no reason, actually she doesn't want to leave the husband, but she just wants to see that he is held by this style of marriage till she possibly can. And the very fact that she can go to Indian Sony Council for the past 10 years, so that she can actually.
how many councils are changed?
5 is how much how many I could count from the auditing, but my remittance is 6.
No, I never said 6. No, even I don't know 5. I don't know. He says, I don't know. By way of reply, only
Yes.
2 points I would like to canvass before this honorable court. The first contention raised by the other side that the wife was guilty of protracting. Now kindly see order sheet dated 18/9/2018 onwards, page 30. From there onwards, the husband also filed many number of applications and he also took time. It is not that the wife, page 30, the statement of objections they have filed, the order sheet.
Statement of?
Statement of objections, the order sheet, page 30.
30.
30. On 18/9/2018, heard both sides on IA. 8 ground satisfied. IA number 6 to 8 allowed on cost of 500. Accordingly, case is reopened. Petitioner is permitted to adduce further evidence. Subsequently also, he also taken many number of adjournments. It is not that only I have been taking time. Now, 5/12/2019, page 32, I have cross-examined him. And 9/4/2019, petitioner is absent. And 1/8/2019, advocate for petitioner prays time. Next. Advocate for petitioner files under IA under 151 CPC and order 16 rule 9. And subsequently standard operating procedure was there, and subsequently also no representation, and again settlement. Settlement was taking place at an intermittent stages. Now, after that, again joint memo was filed. It was sent for mediation. This is as far as the contention that I alone was responsible for the protraction of the case. That is wrong. And as far as these two decisions are concerned, with respect, I submit a 2023 SEC 497. It is on merits. It is on merits, the Honorable Supreme Court has stated. So it is not arising out of any interlocutory application. And the matter was dealt on merits, and therefore this particular judgment is not applicable to the facts and circumstances. So also 2023 SEC online 1127. Now the decision which I have relied upon is the outcome of all the decisions previously dealt with in relation to Order 6 Rule 17. And ultimately the Honorable Supreme Court in 2024 culled out all the parameters, where what are all the parameters the Supreme Court has laid down in this latest judgment. So therefore, the previous judgments with respect to this Honorable Court and the other judgments, I respectfully disagree with the other side that those decisions are applicable. Now, in view of the latest decision of the Supreme Court, no hardship and injury will be caused to the other side. And since it is a matrimonial case, where section 23 is a legal concept and a legal ground, which may, which affects the case of the petitioner also on account of fraud. In 1994, your lordship may kindly see, in Changal Naidu's case, the Honorable Supreme Court has laid down that fraud initiates everything. And in Papaya Shastri's case in 1995, Supreme Court has stated that fraud can be raised at any stage, even in a supplementary proceedings also, at any stage, at any point of time. Therefore, this aspect of fraud is a fulcrum point where it has got to be decided by the Honorable Trial Court. So in order to bring the attention of the Honorable Court, it is necessary that proper pleadings have to be there on record. Otherwise, I'm not taking new ground. No injustice will be caused.
Now all evidence are over.
Evidence are all over. I will not lead any evidence at all.
You are not leading any
I
evidence.
am not going to lead any evidence. That's what I have been stating. All evidence is on there. Whole lot of evidence is there. With respect, I submit. ಅವರು ಸಾಕಷ್ಟು ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ದಾರೆ, ನಾವು ಮಾಡಿದೀವಿ. ಆದ್ರೆ ಅದನ್ನೆಲ್ಲ ಕಲೌಟ್ ಮಾಡಿದ್ರೆ 10 ಪೇಜ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ. ನಮ್ದು ತಪ್ಪಿದೆ, ಅವ್ರದ್ದು ತಪ್ಪಿದೆ. ನಾನು ಅದನ್ನ ಕೆಳಗಿನ ಕೋರ್ಟಲ್ಲೇ ಹೇಳಿದ್ದೆ. ಎವಿಡೆನ್ಸೇ ಇಷ್ಟಪ್ಪ ಇದೆ. ಎವಿಡೆನ್ಸೇ ಇಷ್ಟಪ್ಪ ಇದೆ. I will not lead any evidence at all. If I want to lead evidence, yes, the other side concern has to be taken into account. Yes, I am protracting this. Now, I am not going to lead any evidence. As on record, the pleadings of the parties are there. If the pleadings discloses all these things coupled with the evidence, then it is up to the trial court to consider all the aspects. Is it not a valid ground which I am asking? It is a fraud. Fraud which
All right, now that all that you have stated, what you have to state by way of pleadings in your evidence, and what prevented you from 2015 till 2024?
No, evidence of the parties completed recently. That's what, by way of a commission, if a commission or commissioner was appointed, and commissioner, he concluded the evidence of both the parties, cross-examination, further examination, everything. Recently, it was concluded, and after that.
So you had to wait for 10 years to wisdom to dawn upon you?
No, it is only a question where presumption, your lordship, I am pushed to the back. I am very certain, but the thing is, the fact remains that, yes, in spite of all these things, whether the mistake of the husband should persist, whether the fraud committed by the petitioner should be encouraged. That is the only contention which I bring it to the notice of this honorable court. Yes, merely because the wife is guilty of all these things, she should not be desisted, or she should not be permitted to raise all these legal grounds. There ultimately he is running away by taking advantage of his own wrong. On record, the evidence discloses other thing otherwise, and he admits in his cross-examination. Therefore, under these circumstances, I have put forth my contentions. It is not that I am going to lead further evidence also. No, I have not stated. No, have I stated in my petition? No, I have not stated that I am going to lead evidence. Therefore, under these circumstances, having come to the conclusion, the Honorable Supreme Court has laid down the parameters. Now, whether I fit into the parameters or not is the question before this Honorable Court.
The case which you have referred, what was the stage of the proceeding?
was, para 4(4). Pursuant an application dated 28 July 2016, filed under Order 16, Rule 14 CPC, seeking the production of the will as well as the agreement. The defendant produced the same. A temporary injunction was also ordered. Para 9, some reference may be. The Civil Court by order dated 14th March 2018 rejected the application, observing that proceedings were well on their way. It was observed that the application had been presented nearly a year and 3 months after the presentation of this proof.
In your statement of objections filed by you to the divorce petition, you have taken up this plea that you cohabited and lived together?
I was living with him under the same roof. Now, your lordship may kindly see in the same affidavit, this I also clarified in the evidence and also in the statement of objections. In statement of objections in para 34, lordship may kindly see, I was living with him. Therefore, the said amendment is only clarificatory. Living with oneself does not necessarily say that I have cohabited with him. Presumption is there.
No, no. My simple question to you is, in the statement of objections filed by you to the divorce petition of the husband, have you stated or denied the fact that you were living with him and you cohabited, and denied his aspect that you moved out and mental cruelty? Did you say anywhere?
Yes, in 34 I have stated I was with him and I was living with him. And even in the evidence,
living with him is okay, sir.
cohabitation ನಾನು ಹೇಳಿಲ್ಲ, ಅದಕ್ಕೆ ಹೇಳ್ತಾರೆ cohabitation word ಬರ್ಲಿಕ್ಕೇನೆ ನಾನು amendment ಕೇಳ್ತಾರೋ.
That took you 10 years.
No, all these years that mediation was taking place, and I
right,
thought,
but what is the due diligence that you have shown? All right, now the judgment which you are referred to has not elaborately dealt with the proviso to Order 6, Rule 17.
No, after in Life Insurance Corporation of India,
all right, the fundamentals of the amendment in any proceedings is that generally it should be allowed if it is within the time of before the trial commences, and otherwise it can be still be allowed at any stage, provided that it does not cause injustice, does not damage the case of the other side. Simple. These are the fundamentals. Now, you have not stated this. Suddenly, you now at the stage of after evidence. After evidence, you come up with this application after the stage of judgment that you want to amend by saying that you have cohabited and had physical relationship.
No, no, it's only.
Now, if that is allowed,
The due diligence, the proviso clause of Order 16, Rule 17 is definitely it is going to have cause greater impact on the petitioner if I were to take any new ground. I am not taking a new ground.
what is this ground?
No, this ground is now presumption of law as well as self-ingrained in my statement of objections, which is nothing but elaborate with respect.
If you think it is already then there, what
No,
is
it is only clarificatory since it is.
clarificatory? If you think it is already there, it is only clarificatory, then there is no need. That's a matter of law, question of law. Because you're relying on section 23.
Your lordship is right, but however, tomorrow if they take a contention that it is not specifically pleaded, then I am pushed to the wall.
That is why you did not plead for 10 years.
I was under the
That is the
impression
only
that you
ground
may
which.
take me. I was under that impression.
No, that is the only ground of your defense to counter. That's your only ground, main ground rather, not only ground. That is your main ground of defense. That he has filed a petition against you, living under the same roof, despite you cohabiting and having conjugal relationship with the husband. That is your main, one of the important ground. You have taken 10 years, you are not bothered, you have changed 5 lawyers. Every time a lawyer comes doesn't mean that you have the right to file amendment and keep protracting the proceedings. Within what time the Hindu Marriage Act contemplates disposal of a petition?
Absolutely.
Record.
My respectful submission, if this honorable court is not inclined to allow the petition, I may be permitted to, even an opportunity may be granted to me for addressing the arguments, and next date of hearing, I will address the argument.
Yes.
Or only arguments.
Arguments he can be provided an opportunity to address his argument. He can raise all these grounds, whatever you urged here.
Yes, that liberty may be granted to me to urge all this.
And why these 2 petitions?
No, one is for petition for divorce, another one is restitution of conjugal rights. In both the petitions, similar application.
So one, it's a defense, the other one, it's a pleading on
It's
the
a pleading. It's a
petition
pleading.
for restitution.
Pleading.
Which is filed subsequently.
The restitution is filed subsequent.
In that you should have taken this defense.
It so happens, your lordship may kindly, it so happens in a matrimonial proceedings, the wife would be under some, even lawyers also say that don't take all these, awkward pleadings. With respect, I submit. That's what usually and they go by that. And ultimately, I fairly admit, ultimately when the situation of this nature, it arises at this point of time.
Now she's a doctor.
He's a doctor.
What is he doing?
He is also a doctor. Doctor in the sense that he is a scientist.
Veterinary.
Veterinary.
Research scientists or doctors?
Research scientist.
Research scientists. Both of them.
Both of them.
Ayurvedic. Oh, you're an IVRI.
The ingenuity of the lawyer. Each lawyer, if your lordship sees, comes with a new set of opinions.
No, I fairly disagree. I don't know why madam has been so persistently, even they have also changed lawyers. No, let them file an affidavit that they have not changed lawyers. They have changed lawyers, many number of lawyers. Have I taken that contention here? I have not taken any contention like that. Is it not the right of the party?
See, Mr. Vagesh, now that this lady is, how old is she now?
He's 45.
How old is the son?
I think 14 years.
No custody petition?
Custody petition has been filed. He has not paid not even half an yearly of a school fee. Not even single rupee has been paid as maintenance. We had to file a petition for the under Domestic Violence Act. Now he is not paying even the ordered amount also. No, I can't say all these things. I can't. I have not stated also. No, I have not stated. Earlier I have not stated. If he had the inclination towards the son, voluntarily he could have done.
See, now you should have tried to see that both these matters are settled, because this lady is more than 45 years. The
ಮಾತಾಡದೆ ಸ್ವಾಮಿ, ತಾವು ಏನ್ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ಅದೇ ರೀತಿ. He has also stated ಒಂದ್ ಹೇಳಿದ್ಲು, ನಾನು ಅವ್ರ ತರನೇ ಮಾತಾಡ್ದೆ ವಿತೌಟ್ ಟೇಕಿಂಗ್ ದಿ ಸೈಡ್ಸ್. ನೀ ಇಷ್ಟು ಪೆಟಿಷನ್ ಹಾಕಿದ್ಯಲ್ಲಮ್ಮ, ಹೆಂಗಮ್ಮ ಬರ್ತಾರೆ ಅಂತ ನಾನೇ ಕೇಳಿದೆ. I don't look at the a brief as a brief.
So why don't you sit and settle it?
And she has.
I will pass an
Yes.
order. No. Is there a possibility from your client that he will take the care of the child service?
No. Not
Sending. Correct. So it's a tit for tat. So if you pay some maintenance, he parts with visitation, all this will happen simultaneously. It cannot. You cannot clap with one hand.
Even I suggested a divorce also. I suggested her 10 ವರ್ಷ ಆಯ್ತು ಏನಕ್ಕಮ್ಮ.
Suggested ಯಾರು? ನಿಮ್ ಕ್ಲೈಂಟ್ ಗ ಅವ್ರಗ?
ನನ್ನ ಕ್ಲೈಂಟ್ಗೆ.
ಏನ್ ಹೇಳ್ತಾರೆ?
ಹೌದು, ಇವತ್ತೊಂದ್ ದಿವಸ ಟೈಮ್ ಕೊಡಿ, ನಾನು ಯೋಚನೆ ಮಾಡಿ. Now she is coming in that line. I spent 2 or 3 hours.
We don't know whether she'll come in your line.
No, definitely there is a progress. Definitely earlier she was not even ready for any settlement.
No, she has to understand now that
Now I have made her known about all these things, and she is
even according to you, if what you're saying is right, if he has got married to somebody else or living with somebody else, time has gone by 10 years. The child has grown. She has moved on. You cannot repair the broken glass.
I have already told the same this thing.
People understand. You can cut short the litigation. Or could heard this petition. These two petitions, madam. These two petitions are filed by the wife. Who's defending the divorce petition filed by the husband under section 13(1)(1)(a) of Hindu Marriage Act in MC number 979 of 2015. And who has initiated a petition for restitution of conjugal rights under section 9 of Hindu Marriage Act in MC 5328 of 2015 against the husband. In both these petitions, the wife filed 2 different applications and 2 different petitions mentioned here and above under Order 6 Rule 17, read with section 151 of the Code of Civil Procedure, seeking for amendment of the pleadings in the statement of objections in the case of divorce which she is defending, and in the petition for restitution of conjugal rights initiated by her, whereby she wants to incorporate a paragraph to show that she was having a cordial and happy relationship with her husband, and she was having regular physical relationship with the husband. And that as on date of filing of the petition by the husband, that is 28/2/2015, they were both living under the same roof and constantly having physical relationship till her father received the notice from the family court in the second address mentioned in the divorce petition. It is further stated for seeking amendment that the husband had not informed her about the filing of the divorce petition, nor he retracted from the physical relationship either before filing of the petition or till the discovery of the filing of the petition by the wife. It is also stated that the wife had constant physical relationship with the husband and that she has not condoned the act of and that he has condoned the act of alleged cruelty under Section 23 of Hindu Marriage Act, and that the husband has played fraud on the respondent by initiating the petition despite living under the same roof by mentioning the same address. Full stop. Para. The above stated amendment is sought to be incorporated in both the petitions by the wife. Full stop. Upon consideration of the application on merits, the learned family court judge has dismissed the petition, the application, and rejected the incorporation of the amendment sought for by the wife. Full stop. Paragraph. It is the vehement contention of learned counsel for the wife that the amendment so filed and sought for is very crucial and important for adjudication of the matter before the court, family court. The family court has not considered the application appropriately and has not taken into relevance the content of the amendment, the law laid down by the Honorable Apex Court with regard to amendment being allowed at any stage of the proceedings, so far as it does not cause any hardship or inconvenience or a divergent view or a 180 degrees turn around in the amendment, which would hamper the case of the husband. And on the facts and circumstances of the case, it is also admitted by the husband that as on date of initiation of the divorce petition, the wife was residing and living under the same roof as apparently seen in the cause title of the divorce petition filed by the husband. Hence, he contends that these are all admitted facts with regard to petition being filed when both of them were residing in the same house and the notice was not served to the wife by hand or neither was it informed. It was only received by the father in the alternate address mentioned in the petition. Full stop. It is further contended by learned counsel for the wife that once there is a cohabitation between the wife and husband, the question of the husband filing a petition for divorce would be barred, as the same would disentitle the husband for any relief when he has cohabited and had conjugal relationship with the wife. Therefore, it is his contention that the husband cannot take advantage of his own wrong as contemplated under Section 23A of the Hindu Marriage Act. Full stop. He further contends that this aspect has not been pleaded very specifically with regard to cohabitation and conjugal relationship, more specifically physical relationship between the wife and husband, and that the husband has played fraud on her. He also contends that all these aspects have been narrated by her in her evidence, and so also cross-examined to a large extent the husband. The evidence in both the petitions have been concluded, and the matter is now set down for judgment, correct?
Yes.
Set down for judgment. At which stage the application came to be?
No, at the stage of arguments.
It's set down for judgment, full stop. Nevertheless, the application IA number 30 for amendment came to be filed when the matter was set down for arguments. But thereafter, the dismissal of this application, the matter is presently set down for judgment. It is a vehement contention of learned counsel for the wife that he is not inclined to lead any further evidence. The amendment sought for is necessary for the reason that the pleadings are the fulcrum of any petition. Hence, if that is not pleaded, then he would not be permitted to raise the said plea in the course of arguments and rely upon the evidence adduced by him. Therefore, he seeks the application being dismissed by the family court is illegal, perverse, arbitrary, and the same requires to be allowed in view of the judgment of the Honorable Apex Court in the case of Dinesh Goyal alias Pappu versus Suman Agrawal, reported in AR 2024 Supreme Court 4779. Full stop. On these grounds, he seeks to allow the petitions and set aside the impugned order passed by the family court in both the cases. Full stop. For contra, learned counsel Srimati So-and-so, Vaishali Hegde, for the husband in both the cases, vehemently contends that the judgment, that the order passed by the family court is sustainable in law. Same does not call for any interference, as it is a well reasoned and considered order. She vehemently contends that the petition filed by the husband is in the year was filed on 28/2/2015. Order that 15/3/15 is the objection statement. 15/3/15 notice was received. The objection statement is filed, and thereafter a restitution of conjugal rights petition is filed by the wife against the husband, which are clubbed and being tried together before the same court. It is further contended by learned counsel for the husband that the matter was posted for passing judgment on 16/11/2021, and thereafter, upon recall, the matter was restored to its original stage, and evidence came to be adduced by both parties on applications by both sides, and thereafter it was posted for recording of further evidence, and post which the matter was posted for arguments of the parties. It is contended by learned counsel that despite taking several adjournments by the wife, the matter was not proceeded further and dilatory tactics were adopted. Time and again, applications were filed and counsels were being changed several times. And each time matter was adjourned by imposing cost on the respondent. Full stop. It is contended that on 17/9/2024, when the matter was posted for filing of written arguments, application IA number 30 came to be filed seeking amendment of the pleadings in both these cases. Therefore, she contends that this application is filed at a very belated stage when the matter was posted for arguments of the respondent wife in the proceedings before the family court. It is contended by her that the application is filed at a belated stage. And as per the provisions of Order 6, Rule 17, the proviso, as per section order as per Order 6, Rule 17, and the proviso therein, the proviso reads as under extract proviso. She contends that to come within the bracket of showing any sympathy or pragmatic approach for the application being allowed, that should have been due diligence by the wife in filing the application for amendment. In the present case on hand, admittedly, the application for amendment is filed at the stage when the matter was posted for arguments of the respondent wife, of the wife who was a respondent before the family court. Full stop. On a careful perusal of the provisions for amendment under Order 6, Rule 17, it is clearly seen that there is an embargo that no application shall be allowed after the trial is commenced unless there is due diligence which requires to be shown by the party seeking such amendment. Full stop. The fact remains that this application is filed after almost 10 years. 9 years, is it? 2024, when it was filed?
9 years.
9 years. 9 years, almost 10 years. Almost 10 years. And it is not the case of the wife that she was not aware of the proceedings. She has changed several lawyers. And ignorance is anyway no bliss. She cannot plead that before this court. She has initiated not only the restitution of conjugal rights petition, she has also defended the divorce petition filed by the husband. And she has led in evidence. She has stepped into the witness box. She has cross-examined the husband through her counsel. Therefore, she is aware of the proceedings happening before the court. The fundamental requirement while filing the application under Order 6, Rule 17 is that it has to be filed well within time as contemplated under the Civil Procedure Code. No doubt it is true that normally, in general circumstances, all amendments should be allowed. And the court should take a pragmatic view to allow the amendments of the applications unless there is a hardship, inconvenience, or grave injustice or damage is caused to the opponent objecting party. In the present case on hand, the wife who is defending the divorce petition and who's filed a petition for restitution has contested the matter for almost 10 years, changed several lawyers. The amendment that is now being sought is to incorporate a paragraph to show that she had good cordial relationship with the husband. She had conjugal bliss or physical relationship with her husband, even as on date of filing of the divorce petition, and continued even after the filing of the divorce petition. These aspects have been pleaded in her objection statement, so also in the restitution of conjugal rights petition. She has cross-examined the husband through her lawyer. Now, to contend that the pleadings are not included in the objection statement and in the restitution of conjugal rights petition, if such a pleading would not affect the rights of the husband, the same could be allowed. But in the present case, she wants to incorporate a pleading to show that she had physical relationship even after the filing of the petition, which in my humble opinion cannot be accepted and cannot be permitted, as not only it would be a bar under the proviso to Order 6 Rule 17, as it is necessary and incumbent upon the wife that despite due diligence, she was unable to raise this plea or take up this amendment before the commencement of trial. Even for the sake of arguments, it is taken that she was unable to incorporate certain pleadings at the stage of trial having commenced, so far as it does not hinder, hamper, and destroy or damage the case of the husband, it could have been allowed. But in the present facts and circumstances of the case, the very aspect of her having physical relationship or conjugal bliss with the husband is the crux of the matter, which probably would directly affect the husband in the amendment so being sought. Full stop. Next paragraph. The fact that the wife does not intend to lead any further evidence itself proves is eminent that all the materials that are required to defend and prove her case have been brought on record by way of pleadings and by way of evidence by her. Under the circumstances, when she does not want to lead any further evidence in the matter, this court is not inclined to accept the theory put forth by the wife that despite due diligence, she was unable to bring forth this amendment at the relevant stage of the petition. Therefore, this is a clear case where the incorporation of the amendment and allowing the application for amendment would damage and prejudice the case of the husband. Therefore, I am not inclined to accept the plea and prayer made by the counsel for the wife. Accordingly, the said aspect has been clearly appreciated and dealt with by the learned judge of the family court by rejecting the application. Full stop. It is also relevant to note that the petition is pending since 2015 before the family court, and both the husband and wife who had instituted the petition, they were aged 36 years, and presently the age of the wife is 45 and that of the husband is 46 years. So they have lost 10 precious years in this litigation without there being any cohabitation after the filing of the case. Under the circumstances, I pass the following order. These two petitions are dismissed. Full stop. In view of the fact that the petitions before the family court is almost 10 years old, and the present stage of the petition is for judgment, I deem it appropriate to direct the family court to provide an opportunity to the wife, to the learned counsel for the wife in both the matters. To address his arguments and thereafter pass an order on merits of the matter. How much time you'll require? Pardon? How much time you'll require to address arguments?
Test stretch, it is not possible because it is burdened with cases there in the family court. I think 2-3 sessions would do.
Within 1 month?
Within 1 month. My respectful, I may be permitted to take all the legal contentions.
Yes. Considering the age of the petition, the family court shall decide the matter within 1 month from the date of receipt of the copy of this order in the special facts and circumstances of the case. You have completed your arguments? You may have to reply.
Again, I think they have to, because the gap is so much. It is up to them. It is up to them.
So you will be able to finish it before the summer vacation. So we'll say 2 months for both arguments and reply by both parties.
2 months.
Madam, you just take it 2 months before the beginning of the summer vacation, where opportunity shall be given to both the petitioner and the respondent. Full stop. Learned counsel for the wife is permitted to take all contentions urged here in accordance to the pleadings and the evidence adduced. And also all legal, of course, all legal options that are available to him. Full stop. Parties are requested to cooperate with the court for expeditious disposal as stated herein in the time-bound manner.
Obliged.
Oh, no possible. Correct. Fine. I appear for the appellant. 43 ನೀವಿದ್ದೀರಾ? Huh? 40? ಏನ್ ಇಂಜುರಿ ಕೇಸಾ? ನೀವು 43.1 ಅಲ್ಲಿ ಇದ್ದೀರಲ್ಲ ಚಂದ್ರಣ್ಣ, ನೀವು ಯಾರು ಓನರಾ? ಕ್ಲೈಮೆಂಟ್. ಇದರಲ್ಲಿ ಪ್ರೋಸೆಸ್ ಫೀ ತಗೊಂಡಿಲ್ವಾ? R1, door lock. R2 insurance company alva. You claimant appellant alva. Who's R1 in your case? Owner, Mali Patil. The Net Counsel Sri Mali Patil PS is directed to take notice for R1 in MFA 5554 of 19. ಇಲ್ಲೇ ಕೂತಿರ್ತಾರಲ್ಲ ಅವರು ಮಲ್ಲಿಕಾರ್ಜುನ್ ನೀವ್ ರೆಡಿ ಅಲ್ಲ ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕಲ್ಲ ನೀವು. ಅವ್ನ್ ಬಿ ಪ್ರದೀಪ್ ಇದಾರಲ್ಲ ಗೊತ್ತಿದ್ಯಾ? ಬಿ ಪ್ರದೀಪ್ ಅವ್ರಿಗೆ ಕೊಡ್ಬೇಕು ನೀವು. 2019 final hearing and should have been here, could have finished this matter. ಇಲ್ರಿ ಮಲ್ಲಿಕಾರ್ಜುನ್ ನಿಮಗೆ NBW ಇಶ್ಯೂ ಮಾಡ್ಬೇಕಾಗಿದೆ. ಅಕ್ನಾಲೇಜ್ಮೆಂಟ್ ಮಾಡಿಸಿ ನಿಮ್ಮ ಇದರಲ್ಲಿ ರಿಸೀವ್ಡ್ ಕಾಪಿ. So liability is fastened on the owner. Our illo.
The driver was not having this. The offending vehicle, driver was not having this.
Which vehicle? Which vehicle?
Car.
So liability is fixed on you or the owner, exclusively on the owner. So your ಮೇಲೆ ಏನಿಲ್ಲ ಹಾಗಾದ್ರೆ.
Insurance company exonerated, liability fixed.
Generated. So he has to come. Otherwise, has he deposited any amount? Deposit ಮಾಡಿದಾರಾ?
Owner deposited any amount.
ಮಾಡಿಲ್ಲ. All right, we'll have it next week. Copy of the appeal memo is served to learned counsel for the insurance company, which is acknowledged. Call this matter next week.
Please, madam.
So you may have to give copy to the other side. Give one copy to him. Copy to be furnished to R1, owner of the vehicle. Yes, next. Who are you, claimant? You are R1, R2. So you have not filed anything. Your owner, nothing is on you. Nothing is on you. No representation on behalf of appellant and respondent number 2. You are 1. You are R2. You are appearing for R2. No representation for appellant and R1. Call this matter next week. Argue the matter. Argue the matter if it is short point. He has to come. How to hear you alone? Next week on date could. We'll have it next week one date. 6th March. You are responding? R1.
Appeal
So
for
filed by the.
Please, madam. Appeal filed by the insurance company, Quantum Mills. The
The petition was filed before the tribunal under Workman Compensation Act. Has calculated the compensation as if it is filed under the Motor Vehicles Act. That is the chief difference, my lords. Now, my lords, if we.
You are ready. May not be possible today. No, are you denying the employment? You are for the
I'm
insurance.
not denying the employment. The
No,
only
whether
quantum is.
employer has come before the court?
No, my lords. No,
No, before the commissioner.
no, no. He has not.
No, he filed statement.
No, my lords.
So
We
what
are
you are-
challenging only quantum means. The
Quantum.
calculation that is arrived at by the tribunal is based on the.
Motor
As
vehicles.
if it is
Motor
filed
vehicle.
under Motor Vehicles Act.
All
There
right.
is different heads would not come under ECA Act. ECA that.
Next week. Award cannot now increase. Yeah. What is the income taken?
No, my lords.
What is the income taken?
8,000 millions. No, income taken is
Correct.
12,500, 12,000 is my lord. 12,000 income is. there.
Correct.
As per, one second. As per ECA Act, as on date of accident, it's 8,000.
When is the accident?
Accident is dated 1/3 to 2030.
1/3,
1/3 2030. It's 8,000.
8,000.
I verify.
Hmm.
My lord, 60% needs to be calculated, my lords, taken for the calculation purpose, my lords. The amputation is a scheduled injury, my lords.
Hmm.
The tribunal has assessed. My lords may kindly see the, if my lords can dispose, I can argue, or else my lords may
See,
kindly take up.
you are anyway not in appeal. If you still want, you can file counter cross objection. If it is going, you are going to get more money, you are welcome to file. Who's stopping you? I'll list it next week.
Please.
Can argue.
My lords may kindly give a date also.
Yes. Both the learned counsels are present. The court time is over. Hence, list this matter next week. Date could, date. 7th. On that day you argue, you see whether if you are going to get more by virtue of ECA, workmen's compensation.
Scheduling, I have calculated, my lords,
You'll
it's
find-
not so. Not so. Obliged.
7. Oh, Mahesh.
Oh, Mahesh. Admitted.
Appear for the respondent.
Yes, sir. There is no representation on behalf of appellant. Learned counsel for R2 is present through VC. Call this matter next week.
48.
Next week, Mr. Mahesh.
Yes, ma'am.
48, Veerabhadra Swami, HP.
Krishna Swami, no representation on either side. Idra, on behalf of appellant, call next week.
49, NS Bhatt.
Same. Yes,
49.
Gopala Krishna. 49 ಆಯ್ತಲ್ಲ 50.
50, Gopal Krishna.
Appear for appearance.
Yeah.
Coming next week, any date maybe.
Next week,
Yes, ma'am. Any date maybe, it's fine.
Gopal Krishna. All right. Learned counsel for the appellant is present. Court time is over, hence call this matter on. So next week, could it?
7th March.
Much obliged.
51, Sadashivaya KG.
Call next week. Yes,
52, S Nirmala.
await TCR. Call next week.
53,
Madam
Swani
was
Hey Olda.
sitting here. ಇದ್ರಲ್ಲ
Serial number 53, Sohani A. Ola.
Counsel for the appellant is present. Since court time is over, call on.
54, Chandrasekhar Rodnavar. Lingaraj HS.
Appears for appellant, my lord.
Hmm.
Case of injury, my lord.
Both ready? Next week. You want call next week.
Serial number 55, Suma K.
14% on matter idiyamma ivattu?
No, sir, the last bit is.
But brother, your matter is settled or what? ಹೌದಾ? ಏನ್ ನಂಬರ್ ಏನು?
105.
115. So you are going to have the distinction of having settled a matter successfully. So they have agreed, some agreement is signed? Joint affidavit. And what is he giving now for the wife and son? 2 lakhs. So this is going to be given now or time is? Some time. In what is that time period? Good. Whether the son is meeting the father? Meet ಆಗ್ತಾ ಇದ್ದಾರಾ? But this man has got married again. Another child is there. No, I know you don't want to admit that in the. But if he's going to support the child, first son, then it will be good because it is not the fault of the child. And moreover, that lady is also little petitioner. She is agreeable for most of the things. And since she is employed, I think it is in the interest of both parties that they settle it, more particularly for your client. The problem in matrimonial disputes is the ego. And that ego is, infuriates their anger. Infuriation of that anger and the counsels coming and further, trying to do the best for their own clients. I'm not blaming the counsel, doing the best for their client. They think that they can go on, but unfortunately they are wasting precious time, which you cannot get back. Or Barley, just make a submission on it.
55, Suma K.
Same call next week. 57.
Number 56, urgent 57, Vishwanath Hegde. 57,
Court time is over, call next week.
58.
Same.
59, 60 urgent. 61, Girish Vibaldare.
Same.
62, Srinivasan invite.
No, same.
63, R. Shashidhara. Ravish Penny. 64, Pradeep B.
For appellant, matter may be referred to local.
Matter may be referred to local. Refer to local Dalat.
Please, my lord.
At request of both parties. Who's appearing for the other side?
Jagdish HT, my lord. Jagdish HT.
Is
HT Jagdish.
consent ಮಾಡಿದಾರೆ?
Please, my lord, please.
Both parties matters refer to Lok Adalat. Yes.
65, Srinivasan MY. 66.
Same.
67 urgent. 68 urgent. 69, Chandrasekharaya.
Same, court time is over.
Bill number 70, SV Hegde Mulkan,
Same.
71 Arjun, 72. 80,
Same order.
73, Jagdish.
Same.
Really manager, Tata AIG.
Yaರಿದ್ದಾರೆ?
Tata AIG, Pradeep.
The Council Sri Pradeep B is there to take notice for R2. Copies to be furnished, registry to show the name. All after 2 weeks.
74.
Appear for appellant.
Number 2, madam.
Appear for appellant. Claim petition dismiss ಆಗಿದೆ.
ಇದು ಬಂದಿಲ್ವಾ records?
Records ಬಂದಿದೆ.
ಇದೆಯಾ?
Time here.
Yes, since court time is over, call this matter next week. ಕಳಿಸಿ.
75, Girimalaya.
Respondent number 2.
Same order, court time.
Bill number 76 Arjun, 77, Sugunamma.
Yes, I prepare the appellant one.
Yes, madam, nobody is there here, other side. We'll have it
Yes.
next week.
Yes, ma'am.
Yes, since court time over, call next week.
78, Renuka HR.
Hey, mat kalbadi. All that matter.
Sir.
ಬಂದಿದ್ದಾರಾ ಇಬ್ರು?
115, Sridevi KS.
Thank you so much. I think your words also inspired me to just, close everything. It's 13 years, pointless. And in the future, if he's friends with my son, he will do without I asking anything. So with that trust, I wanted to close.
Good, I should appreciate both of you and him also, that you have agreed to put an end to this ordeal, which you have been going through for the past 13 years.
It's the same thing I asked 13 years back, 8 years back, 6 years back, 4 years back. He didn't open his mouth. He was not at all willing to even give 1 rupee. His view was very different. But today he's in a very helpless situation. It's not that he doesn't have money. He has money which is blocked by the bad people.
Alright,
Whatever
anyway,
it
let
is.
us assume that wisdom has dawned on him now.
Yeah, yes, agree.
So you can at least part as good friends, if
Yeah,
not going to
agree.
be partners.
Agree, agree.
And he will take care of both of your son.
Yeah.
Son by both of you.
And one of the reason to settle is that one of the very good memory is and blessing was his chain, which he agreed to give. And also he agreed to settle everything by 25th April. My son turns 18 on 29th April. So this is the best gift that I can give him. So, and he's waiting for this moment.
So
So
your
with that intention, I had to agree with
son is meeting him?
son is meeting him, but he doesn't talk. He doesn't even bring anything. He doesn't even ask, how are you?
Matter. No, now it may change.
It will change.
Certainly.
Yeah,
Change.
certainly it will change.
Certainly. You have to also give him some.
Yeah, he's one of the topper in the JEE main. My son, out of 20 affiliated colleges, is top 8. And, this is the last thing that I want to spend my time on. So,
So the terms and conditions are an agree to pay 10 lakh rupees towards permanent maintenance of petitioner number 2, that is Master Paramik EC. And a gold chain is given already.
no, he'll give on 11th March along with 1 lakh.
I'm handing over the DD for 2 lakhs today.
Yes.
As per the terms.
Just see the every entry is correct. Your name is
Yes,
correct.
name is spelled correctly. Yeah.
Date and amount.
2 lakh, 12th February 2025 dated.
12th February. It was drawn earlier, last week.
Last week.
Yeah, he said he'll only give once affidavit is signed.
So another 1 lakh is to be paid on 11th March.
11th.
So 11th March could be the next date. So we'll collect both the chain and the DD on that day. Mr. Husband, please no excuses on that day.
I will dispose of this matter.
It can be.
Um,
It can be disposed of. This matter can be disposed of because several other petitions are pending. Upon receipt of all rest of the amount, she will going to withdraw them.
okay.
That has been agreed.
Anyway, now that you have put all this in writing.
Yes. Yes.
This will become a part of the record.
Okay.
So if he doesn't comply any of it, I'll reserve liberty for you to revive this case.
Please.
Okay, my
Which
lordship.
will not happen.
Which will not happen. Even I hope so. Lordship, I had actually mentioned it will be given in this court. So he can give anywhere and present it, right? Update it.
Yes.
And
This order can be produced.
okay. Okay.
We'll produce it.
Okay.
How much is the amount you are giving to the petitioner?
2 lakhs.
Ivaga.
ಇಲ್ಲ ಇವಾಗ ಕೊಟ್ಟಿದ್ದು ಮಗುನಿಗೆ.
Now
ಮಗು ಕೊಟ್ಟಿದೆ.
what you have given is now to the
2
Petitioner
lakhs
two.
is for petition
Number
number 2.
It's subparagraph A under C.
A.
A under C. C A.
2 lakhs to Pramit Bhaskar. Okay, that is handed over.
Yes.
So 1 lakh will be given on 11/3 to you.
1 lakh
Again,
is
again in the favor of Pramit Bhaskar only, child only. So CA is 2 lakh for Pramit and CB is 1 lakh for Pramit and CC is remaining 7 lakhs for Pramit and 2 lakhs for
that's for the
me.
petition.
All right.
Please.
All right. So what is now pending before the family court?
Divorce petition.
Divorce petition
Yes.
only.
Divorce petition only.
And there is a 498A.
498 is also pending before CM.
That is stayed or not stayed?
Not.
No. objections.
So there has to be an order passed by this court for, please, to quash that.
My lordship, there are 3 petitions apart from this. One filed by respondent for the divorce. The other 2 petitions are criminal petitions, which is under the traffic court and the CMM court.
So
One
the
is pen-
traffic course is domestic
It can,
violence?
no,
Domestic
domestic
violence.
violence act, it can be withdrawn by the other side.
No, I think let this court pass the order, putting an end to all these litigations.
Yes, my
I'll
lordship.
keep it open so that let him bring that chain
Yes,
and that remaining amount on the next date.
Please.
I list it on 11th,
March.
so that this court can put an end to all the litigation.
Great.
So that
Great.
again, there should not be that you are not given this, not given that.
Please.
All right?
Please.
Great.
Learned, the party in person, Srimati Sri Devi KS is present physically. The respondent, Sri BP Chetan, is present physically before the court, along with his counsel, Sri Ravi Shankar TP. Please. Respondent counsel, Sri Ravi Shankar TP, hands over a demand draft for rupees 2 lakhs, bearing number 876417, CA alidema, capital CA alidema, SBI so-and-so in favor of so-and-so, which is received and acknowledged by the party in person, Srimati Sri Devi KS, who's none other than petitioner number 1, mother of petitioner number 2. On behalf of the minor child. For compliance of clause B of C, capital C, this matter on 11th March 2025. March, Mr. Counsel.
11th March.
So on that day, he can bring that balance amount.
1 lakh
one
DD
lakh.
and a chain will be brought on
That chain.
Yes. Will brought on.
We'll put an end to it on that day. Yes, you can come on 11th. You have signed?
No.
Order sheet. Guide ಮಾಡಿ ಎಲ್ಲಿ sign ಮಾಡಬೇಕು ಅಂತ.
Is that joint affidavit is part of the record? Because I need to produce before the trial.
You want to produce?
Let it be brought on record.
Learned the Srimati Sri Devi case, 14%, and so and so. I filed a joint affidavit. Joint affidavit. Could you? Yeah, who's come with you, madam?
My mother is here.
What is her name? Sujata Bose. Okay. 14% so and so is accompanied by her mother, Srimati so and so, who identifies her. Joint affidavit is taken on record, which is duly sworn to before the notary. All right.
Great.
On the next day, just close it.
Certainly.
See that there is no dispute on the chain further now.
ಇಲ್ಲ ಹಾಗಾಗುತ್ತೆ.
Mr. Chetan, you take care of the son, speak to him, develop relationship. On ಮಾಡಿ, mic on ಮಾಡಿ.
All these years, I don't want to disturb my son because he was in such a stage where he couldn't. So again, in future, it should not happen. That is why I didn't meet him all these years.
All right, ಇವಾಗ settlement ಆಗಿದೆಯಲ್ಲ,
Okay, sir.
ಮಾತಾಡಿ.
Okay, sir.
Get good relationship with him so that he can grow up, be a good individual with love and affection of both.
Okay.
Mother has taken care from all these years. Could not miss you in case participate on his birthday, in future educational his endeavors.
Okay,
All
sir.
right,
Sure,
maybe
sir.
his marriage and other things.
Okay, sir. Thank you, sir.
All right.
Thank you, my lordship.
Yes, yes, God. Very good.
78,
78.
Oriental Insurance Company, hard.
ಯಾರಿದ್ದಾರೆ?
BC ಶಿವನಗೌಡ,
ಯಾರಿದ್ದಾರೆ? Oriental Insurance.
BC ಶಿವನಗೌಡ, ಶಂಕರ್ ರೆಡ್ಡಿ.
Learned Counsel Sri BC Shivannegowda is directed to take notice for R2. Copies to be furnished. All this matter next week. Delay condone ಆಗ್ಬೇಕಾ? Claimant the crop al yaru. Lakshmi Shrav is for claimant. IE 1 of 23 is allowed. Dispensation of certified copy of the judgment is permitted. 2 of 23 is allowed. Delay of 25 days is condoned.
One mentioned 117, is there a possibility somewhere in this week? It's a very small matter.
170.
117.
It's RPFC.
It's a rate against maintenance. It was based on fraud. I'll take my chances this week if it could be.
We'll have it next week.
I'm sorry, 118.
18.
118.
Next week.
Next week. The rosters may change, I'm just taking it. It's possible.
If roster changes, you take a chance before the next one.
Any which way, it's all this.
If it doesn't change, you can come before me.
Very well, that's good.
Because this week we are fully, the board is full.
Very good.
Huh?